Love you, Linda. Love you.
The courthouse the other day in the hallway, you're singing "Oh Happy Day."
One word prayer. Justice, where are you?
Well, good morning. Justice Served TV is on the air, and we're here kind of especially early. Not early for, I guess, a trial date, but early for our normal purposes. Michael Bryant here, Linda Kenny Bodden on assignment, but she'll be joining a little bit later on, probably at the lunch break, which we expect to be at about 1 o'clock Eastern Daylight Time. In the meantime, though, with the hearing beginning at 11, we thought we would just chat for a minute, kind of get a sense of what's happening today. I have no idea. I mean, I would be lying to say I've somehow kept up with every single motion in limine that's been presented and or ruled upon. I could say most of them have not been ruled upon. We still got a bunch more that need to be argued. I don't know. We're going to see if the speed dating 2-minute rule is in effect for today, because I can't imagine, based on what we've already seen in the Karen Reed case, the motions in limine, which exceeded 40. Did we get to 10? Did we even get that far? So we got a bunch of those to do. They're starting late today. I'm just assuming because the court had not originally scheduled this date for more hearings, but it just continues to snowball forward, and she probably had other stuff to do in her 9 to 11 chunk, or she was getting her hair done. I don't know. I have no idea. But it's starting at 11 o'clock, and we'll pick up where they left off with the motions in limine. I assume they'll also maybe give some indication of the rulings on those that were heard last week. We thought we might get some of those yesterday, but nothing came through on that front. So a couple of things to chat about. I was going to get right into one thing that has been all a buzz on online. It's the mass trans report, and mass trans is not a bus that takes transsexuals from one place to another. That's not mass trans. It's the Massachusetts Transportation Board report, and we will get into that because my legal opinion is it's a lot of hooey, but it is kind of fun to talk about. But look at this. Check this out. This is see what that. Let me see if I can hold this up. You see that? Off official summons for jury service. I can no longer say that I have never been summoned for jury service. And we were just talking about the Karen Reed case and the jury questionnaire that we went over on that. I actually took some screenshots of the jury questionnaire that I had to fill out for. It's just generic. It's not for a specific case. And I'm probably going to have to ask for a deferral, as they call it, because the date they've got me coming in there is middle of June, right on top of some filing deadlines that I'll be swamped. I know I'll be swamped. And I don't think I want to just go sit in the jury selection room while stuff is grinding. I think the next day is actually the deadline I'm up against with a number of cases. So I'm definitely going because I want to walk through that process with everybody, because I've never done it before. So I think it'll be interesting content, hopefully. But it happened. So funny. It happened just yesterday. Came in the mail. Okay, let's talk about this form. I'm going to bring it up, and I'm telling you, if it weren't for the magic of the Zoom feature, I don't know how anybody could possibly read this. Thanks to Diz for getting this pulled up, and then I will do what I can to make it legible for everybody. Again, this is a document that is reported by the. Let me put the caption up here for you if I can find that. Okay, it's an impact report, they call it. Okay, so this is done in theory anytime there is a motor vehicle collision, either car on car, person, dog, whatever the crash may be. So everybody's all excited about this document, those on the Free Karen Reed side, and I admit it's definitely good red meat for those folks. But here's why I'm going to tell you, I think it's a bunch of hooey over nothing. First of all, let's get some of the details that I think people are focusing on. Okay, here is, and this is a screenshot. It's a multi-layer form, and you can go on that site if you want to go look for any type of a crash you want to look for. Here's the result of the crash. Okay, this is Norfolk County, no hit and run. Okay, that's interesting. That's somebody's decision somewhere. No hit and run. Here's the date, 1/29, right? And it is non-fatal. And if we pulled up the coordinates, which I'm not going to do for you, I mean, look at this form. It's just a mess. But if we pulled up the coordinates, you would find it is 34 Fairview where this took place. Okay. So that's the basic injury, basic information, non-fatal injury, non-fatal injury. Okay. That's one of the key bits and pieces on here. Let's go a little further down. Let's look at the crash info. Crash date. Okay. This is going to make one of my points for me. Crash date 1/28/22. Crash time 12:33. Somebody please tell these people that you see when the clock strikes midnight, it's the next day. So either this happened amazingly at the same location a day before, or they just screwed up the date on it. I mean, if you're screwing up the most fundamental information, how reliable is something like this? It should say, of course, 1/29/22. The time people have focused on, 12:33, and they referenced that time with the time where Karen Reed's allegedly connected to the Wi-Fi at Officer John O'Keefe's home, which was 12:36. Okay, so and of course, Mr. Lally in trial one and others in the prosecution have constantly said it was 12:45 when the incident took place. So that is interesting, but there's so much crap on this report that kind of waters down any real import. Okay, here there's weather conditions. Not reported. Road surface. Don't worry about it. Crash severity, non-fatal injury. Okay, interesting. Let me see if there's anything else on here before we move on to page number 2 and the result that everybody is so excited about. Buffer. I find this interesting. Here, the buffer. Now, this for a crash scene would be, the cordoned off area, right, where somebody is posted, or there's at least there's some crime scene tape, something. And we know there was nothing at the property. They didn't even post a vehicle there to protect the crime scene, the alleged crime scene. They put no tape around the crime scene. So here they list the buffer at 1,000 feet. I don't know. Was that to keep, stray animals away? Because there was nothing to keep people out of the way. It's very theoretical. But on this form, there was a 1,000-foot buffer zone. I don't think so. Okay, let's see. There's one other note on here. They have the ages of the participants. They listed as youngest driver, oldest driver. Well, there's only one driver, so I'm not sure exactly how that was written down as it was. Not federally reported or reportable. I think that's because if it doesn't involve maybe some guns or drugs or something that might impact federal law, that's just a motor vehicle incident to them. Again, no hit and run, non-fatal injury. So where's the final little note I was looking for here? Let's see. Lovely drawing. And again, this is the coordinates are for 34 Fairview Road. That's not disputed. That's not an issue. So they're basically saying it's a non-fatal injury, and somewhere on here it specifically says did not cause the death. And I'm sorry I can't find it now. I thought I had seen it earlier. But that was the term that got everybody all in a lather. Here's my problem with this form: evidentiary and substance. First of all, I don't know that you're ever going to get a document like this into this trial. There we go. Deceased not caused by crash. Oh my God, there it is. That's it. The case is over. It's the Karen Reed keep out of jail free card. This is it. This is the one. Yeah, right. These reports, just to give you the foundation on these reports, are written up by guys who are like, all right, it was vehicle 1 bumped into vehicle 2, and then I'm not sure why they're speaking with Southern accents in Boston, but nonetheless, it looks like vehicle 1 exploded when vehicle 2 ran into it, and the driver of vehicle 1 got burned to a crisp, died. There you go. That's the level of expertise and experience you're getting with something like this kind of report. This is not a scientific report. There's no expert analysis going on here. This is a guy or a woman that takes this stuff down as routine, and they're used to dealing with fender benders, cars on the highway that maybe stop short and the other person rear ends them. This is not that kind of case. And so this is one of their default positions, I'm sure. Deceased not caused by crash. That's probably one of the boxes they have to check, and then it populates that category right there. It's useless. Let's say you're going to try and bring this in. First of all, I'm going to object on foundational grounds. So maybe you bring the person who regularly maintains these documents in the normal course and scope of the business. In this case, the business of, I guess it's the government transportation, the state transportation department. Yes, I'm Bill Smith, and I always prepare these reports. We do it every day. We do it at or about the time of the incident. Contemporaneousness is required. And this is the way we always fill these out, and I can attest to that. And this is the way this one's filled out properly. Okay, so now you have the physical document might get in if you've got that. But then you're going to start drilling down to these details that I've talked about, and you've got no foundation for them. You have to bring in a few folks, whoever weighed in on these ultimate decisions. And I guarantee you, it ain't going to be pretty. It's not going to be something that impresses a jury, helps a jury, or helps a prosecution or defense make their case or defend their case. It's just not. But it's great to talk about. Very interesting, fun form. But I just thought we might address that since I saw it burning up the internet earlier today. So I think that's about as far as it's going to go. I will be shocked if anybody even attempts to get this in and somehow prove that, hey, this was not a hit and run and Karen Read could not have done anything because the death was not even caused by the accident, if there was an accident. Well, we already got an ME with an undetermined cause of death. We already know that, among other things, hypothermia, exposure led to Officer John O'Keefe's death. This doesn't do anything to move the ball. So I say get rid of it. I say it ain't going anywhere. Okay. So as we get ready for these latest hearings coming up, I thought it'd be interesting, and maybe you've seen some of this. There are selectmen, council, town meetings that take place. I don't know if it's monthly or weekly. This one I've got for you is from last week. And having been in Canton, having spent a little time wandering the streets there, meeting some of the folks, and getting a sense of how that community is feeling about this phenomenon, and that's certainly what it is. That's probably the nicest thing I could say about it. They have a chance to go to these meetings and speak out about what's happening in their town. Remember that the folks who own D&E Pizza, right, just happened to be on the council. Chris Albert is a selectman. So people have thoughts about his involvement, what's happening in this case, and I think it's going to be worth taking a look at one of these meetings. Okay, just this was, again, it was from last week. And it is, I thought it was a trip. It's just, what you have is people lining up in the, people lining up, let them get a little plug in for their production. Okay. This is
our agenda tonight. We start with public comment. And as I do each meeting, I will read the following statement. The public comment portion of the meeting is an opportunity to listen to residents' feedback and concerns, but the public comment portion of the meeting is not meant to be a question and answer format. There will be no response to any public comment when presented. The public comment portion of the meeting is limited to 15 minutes total and up to 3 minutes per speaker. Those that wish to speak should stand at the microphone and wait to be recognized by the chair. Please state your name and what town you live in. You do not need to give your address. I would ask that all members of our audience to be respectful of each speaker as well as each other. Anyone who does not wish to speak or who is unable to speak due to the time limit may submit their comments in writing for the board's review and consideration. So with that being said, we will start public comments at 7:04.
Okay, so the ground rules are a joke. No Q&A. We're not going to respond to anything. You go ahead and you get up there and vent. You be your craziness. Get that off your chest, and then we'll go ahead with our real meeting. You have a max of 3 minutes. The whole process is no more than 15 minutes, right? So is it useful? I think maybe people watching it, as I did, and as we're going to share just a piece of this, will give you a sense of the community and what they think. And, to go to one of these meetings is frustrating. It's nerve-wracking. I give those who took the opportunity and the time to speak, I give them all the credit in the world, knowing that what they're saying is probably falling literally on deaf ears. I guess maybe some folks in the audience might have some thoughts they can share. So I'm going to skip through the first speaker. I will tell you, gave us some voting updates as to when you could vote and how that was all going to work out. Okay, so that's what this young woman here is doing, and then she's going to finish, and the next person is much more.
Tap it again just to make sure.
That's just for the that's for the TV.
So can you hear me?
Yeah.
I can. Okay. Brenda Sweeney, Canton resident. My humble opinion. I'm feeling philosophical.
Oh wait, this
today.
is the wrong
Just
one.
some
Sorry,
food for
I
thought.
did like her. I thought
Just-
she was interesting. If you get a chance, listen to her. She just did this kind of stream of consciousness comment on karma. You see her shirt says karma. So she's just kind of talking about what she thinks karma is all about and how it impacts your life. Not exactly why I tuned in. So I'm going to skip that one. Maybe that's karma. I don't know. Okay, so here we go. This one I think you'll find interesting.
Understand how we're not asking.
Okay, let me get her full intro so that she's properly recognized by me, if not by the board.
Jennifer O'Donnell, I actually didn't want to stand up here or speak, but I don't understand how we're not asking the question. Like, Helena Rafferty walked the O'Keefes into the courtroom.
That's Chief
She's
Rafferty.
been hiding in the police station for almost a year. And her one outing from the police station was to walk the O'Keefes in. And this has nothing to do with the O'Keefes. It has to do with a public perception. And everyone's narrative is that we who support Karen Reed are swaying the public perception and tainting the jury pool. The chief of police from the town of Canton, if you're not going to stand up and be the chief of police and address the public when they're asking you for something, you showing up at court sends a strong message, and that sure as hell taints a jury pool. My only other comment that I wanted to ask is, how are we not addressing that Chris Albert is recording citizens and is once again back in the spotlight? He seems to be very involved in this case, yet he still gets to sit on the board. He's a public figure who is using our resources to bring citizens to court to flex his abuse of the town resources. He is far from a sensitive witness who he is in such a public role. If you are having such a strong time and a hard time at home, you need to pull back. You need to not be representing our town because it's hurting our town. It's causing a circus to come to our town. Citizens did not know that they were being recorded both with audio and visual.
Please be quiet.
Yep. My moment. I don't know what the legal law is, but I do think that if it's being used in the public court form to prosecute witnesses for witness intimidation or people for going after him because he's so protected as a witness in this fucking case.
Whoops.
Get off the board. You're part of the case. Pick one side. You can't do both. And we can't all sit here and support him doing both. It's one or the other. He's protected as a witness in this case in using our resources at his will, or he's a select board member using his resources for the town. Which is it? But he can't do both. So I don't understand why no one came up to the microphone to ask that. And I don't know if I have time, and I don't care if I have time, because I just didn't understand why no one would ask those questions.
Thank you, Ms. O'Donnell.
All right, then. So I was looking for a document.
Rita Lombardi.
We just loaded up here.
Canton will hold its annual town election on
Hey, wait.
Tuesday,
This
April
is
8th.
important.
There are two candidates for select board. Since 1989, John Conley has been a member of the select board. After 35 years on
So it's a little PR announcement. I think there's one other one that's interesting here. DIS said they just loaded up a new document, opposition to excluding third party. So I'm going to try and find that. Let me see if I can. I think there was one other person that had something interesting on the Karen Reed matter. You can see how incensed some people are, with the whole Chris Albert connection. I get Brian's
after Chris-
confused. All the incestuous nature of this select board.
stemming from 1990.
It's outrageous that why don't you step aside, dude? Let this trial finish, let the chips fall where they may, and then if you want to get back into your powerful select man role, run again, do it. But who are you helping? You're just making it sound even more like there's this deep state within Canton that does what they want to do, a star chamber, what they want to do when they want to do it, and step out of line and they'll straighten you out. I don't understand how that helps. I mean, come on, dude, it's selectmen. Where's that? Just barely above postal worker. And I'm sorry, I'm probably offending postal workers by saying that. I mean, it's not a big deal, dude. It's talk about a tiny fish in a puddle. Step aside. And you can hear that's what some of these citizens think is the right thing to do. I'm kind of for doing the right thing. Let's see. I think there was one more.
State your name.
Oh, Gilda McGonigal.
Thank you.
10 Partridge Way, Canton.
Hey, just gave it your address.
So
You're
it
not
was more
supposed
than
to do
just
that.
John Connolly that supported Chris Albert. It was the Canton voters who voted for him and elected him. I wanted to say thank you to John Connolly because since he
Yeah, this was a longtime guy who served well, apparently, and was somebody like
was overseeing the development.
There's all kinds of things that he did. That may be the only one that ended up being worthwhile. I'm sorry.
You've got 1 minute, sir.
Excellent.
Oh.
Mr. Chairman, I just want to,
This
State
one,
your name.
interesting.
Nicholas Corkery, Canton, Mass. I want to make two
Oh
statements.
no,
One,
this guy again.
Citizens of Canton.
Oh no, this guy.
I don't know who's that. I don't know who's
Mr.
saying that.
Albert, recall him. Stop heckling him. Do something about it, whatever it is. Next time he's up for election, don't vote for him, whatever. But
This
this
is
is
anti-Chris
consistently
Albert.
the same old every week. So unless they're going to do something about, I don't know what to tell them. In regards to Michael Lank, who happens to be one of my best friends, he is a good police officer. He's been promoted for doing good things for Canton. If you look up his record over and above what's been alluded to, he's done quite a bit for Canton. We're grateful for him.
Okay, so again, once again, somebody with a couple of words to suggest maybe that Chris Albert should find something else to do. Now, I've just downloaded. I've not looked at it. I have no idea what's going on with it. I'm going to try and open it up here for us. This is apparently an opposition that has just been filed. Let's see if I can get that for you. There we go. Let's see. Again, this is the memorandum of law in opposition to Commonwealth's motion to eliminate to preclude the defendant from raising a third-party culprit defense. Okay, we know this is obviously hot stuff. Let me get rid of this and bring in the document. Okay, here we go. Bear with me a second. There we go. 1, 2, 3. Okay, so this is hot off the press. Let's see if we can read the. Looks like it was filed at 8:05 this morning. It looks like so. The ink is still a little bit wet here. I'm just going to kind of read through it briefly just to get a sense of where they're going here. Don't want to give anybody whiplash or anything. I'm not going to zip through it. We know the relevant facts, blah, blah, blah. Now, remember, and this is important. I don't remember this from trial one, but apparently Yannetti did make these statements in trial one where he identified the 3 people they thought were most likely to be the third-party culprit, whether acting together or individually. Brian Albert, Chris Albert, and I'm sorry, Brian Higgins, Chris Albert, Colin Albert. So those names came up in the last hearing as well, and it was not the first time. He actually had mentioned those in the first trial as well. So here we're now focusing on those 3 since they've been identified yet again. Brian Albert, talking about his connection to the cops, but says Brian Albert did not have a good reputation among his fellow police officers. He was known as the bully. Okay. So this is the defense trying to bolster their argument to get these guys some level of evidence about their actions into this second trial. Brian Albert admits to having been home at all relevant times. Okay, we think that's true. And then this is one of the key arguments by the defense, of course, looking at the evidence, including computer forensic data, overwhelmingly establishes that John O'Keefe entered Brian Albert's house. So that's one of the huge issues here. Hey, while I'm thinking about it, we were going to have, I don't know if we do or not, Diz, we were going to have Tom CPU was doing live outside the courthouse. Were we going to have that feed available or not? If so, and it gets popped in there, I'll bring it in. Brian Albert drinking heavily throughout the day and night in question, spent the day and night with Brian Higgins, and then goes into this, the whole Brian Higgins romantic interest in Karen Reed. So laying the groundwork for what they believe, what the defense believes is a reason to have a physical altercation between Brian Higgins, Brian Albert, and Officer John O'Keefe. O'Keefe's, as we move into the third page here, Mr. O'Keefe has injuries and wounds on his right arm from an animal or dog attack. Obviously, that's disputed. Brian Albert had a large German Shepherd at the location on the night of the attack. The German Shepherd, which indisputably has a history of violent dog and human attacks, apparently too. This aggressive and violent German Shepherd was, according to Brian Albert, not good with strangers. None of this evidence was investigated by the police, that we know. In fact, the evidence shows that was by design. Again, defense argument there. Ex-trooper Procta, the Procta Facta, was asked in a text exchange whether the homeowner would catch grief as a result of having a dead body of a police officer on his front yard. Michael Proctor's response demonstrated his intent to protect a fellow police officer. Quote, "Nope, the homeowner is a Boston cop too." Now, when he testified, he said that was just explanatory. It wasn't sort of, who's living there? It's Brian Albert. Oh, he's a Boston cop too. Not that, hey, things are fine because he's a Boston cop too. Obviously, that's the way the defense thinks that should be spun. Consciousness of guilt. Hey, in this case, not against Karen Reed, based on interactions with Aidan Carney. And by the way, Aidan will be here tomorrow night at 8 o'clock. We're going to get an update from him. Micah, what are you trying to say about the people in the South there, Michael? I was just dropped an accent in when I was talking about the traffic report. Nothing personal, just kind of, I watch a lot of TV, I guess. Let's see. It's worth noting that the Brian Albert was at all times a first responder himself, yet he chose to ignore his duty to help someone. That is odd, I think, that somebody wouldn't come out and at least, see what's going on. You're all in the house asleep. That's, I believe, what the basic testimony is. The cops are there. They find a body on your lawn. And, I mean, it's not all that late at that point, right? You don't even come out and see if you can help or see what's going on. I do think that's weird. Any reasonable investigation would have seized upon the combination of this suspicious conduct in furtherance of a fulsome investigation into the death of Officer John O'Keefe. Okay, so there's your first of the three, the trifecta here. That's Brian Albert. Brian Higgins, we know the romantic connection. Let's see where else this thing goes. He was at the scene of the crime. Yeah, that I think is undisputed. They, of course, reference that John O'Keefe went into the house. That is very much disputed. Brian Higgins has engaged in a flirtatious text message exchange with Ms. Reed in the weeks leading up to January 29, 2022. He has testified that Ms. Reed had kissed him after he watched an NFL playoff game with her and others not long before January 29. He testified Ms. Reed visited him at his apartment after that, but Higgins acknowledged that the text message flirtations and all contact between them ended, and that Ms. Reed was the one to end it. She stopped responding to him. She no longer gave him any attention. This was after Higgins indicated in multiple text messages that he was interested in her and found her attractive. We've seen all of those little, high school flirtatious text messages. So there's defense is saying it ultimately went nowhere, but maybe because it was Karen Reed's decision that it went nowhere. That puts him squarely in the crosshairs of some altercation that night. There is evidence Mr. Higgins wanted to lure Mr. O'Keefe into Albert residence. That's interesting. At the waterfall, minutes before he leaves, Higgins motions to Mr. O'Keefe, then follows up with a text message to make sure he's going to be there. Now, you've seen that interaction at the bar there as they're leaving. And now the defense is pairing that with the follow-up text message, which was basically, are you coming over? Are you going to be there? They had given him the address of 34 Fairview. So the defense is linking all of that to build this story that Higgins was out to get Officer John O'Keefe. either because he felt Karen Reed shunned him as a result of O'Keefe or some other reason. But that's what he's suggesting here in this latest filing. Again, this was just filed a couple hours ago. When Higgins went home that night, didn't go to sleep right away. At 2:22 a.m., he speaks by phone with Brian Albert, tries to claim that the phone records reflect. This was, I think, perhaps one of the first butt dials. I can't remember the whole sequence, but there were a good number of butt dials that night. It's crazy how many butt dials there were, and butt answers as well. That's even weirder. Yeah, everybody's had a butt dial every now and then. Have you ever had a butt answer? I'm not so sure I have. When Higgins realized the defense was interested in seeing the contents of his phone, the defense motion has been filed, he further demonstrated consciousness of guilt. How did he do that? You guys know he got rid of his phone and his SIM card. And how he got rid of it was interesting. They lay it out here. He destroyed the SIM card, then traveled to a military base to put that tiny object, it's a SIM card, into a large dumpster. Higgins' conduct on the night in question was followed, establishing clear evidence that should have been investigated during the course of the investigation, but which evidence was ignored by Michael Proctor and his supervisors. And then we have the third of this trifecta of evil, according to the defense, Colin Albert. He had been in a feud with Officer John O'Keefe in the weeks and months leading up to January 29. Let's see how they fleshed that out. He threw beer cans at Mr. O'Keefe's bushes and told Mr. O'Keefe to F off to his face. Testified under oath he had never been in a fight in his life, yet there's video evidence of him taunting others to fight. Desperate for violence. Colin Albert, after his death, was photographed with knuckles scraped. We know that very well, consistent with the injuries he would have suffered in a physical altercation. All this is very interesting. All of it certainly going to come up at trial. But remember what the prosecution is trying to do, and that's just foreclose this right out of the box. We're not going to have the defense talk about these potential third-party culprits. We just aren't going to get there. And so the defense is laying the groundwork, not just for the examination to come, but they want the court to do what they should do, in my opinion. Let it in. It's coming in. Okay. This is just a primer and a preview of what you're going to hear when these folks testify, as they did the first time. Colin Albert's name was purposely omitted from the police reports. No indication in any of the reports provided by the defense in the first months of this provided to the defense in the first months of this investigation that Colin Albert was anywhere near 34 Fairview Road. And of course, that's his uncle's house. In fact, there was no indication in those police reports that Colin Albert even existed. And that is odd, but it's consistent with not even checking in the house, not even going in to look around, talk to people who were there. For those who are following the conspiracy theory, this feeds right into it, of course. It's a reasonable inference from the evidence, finally and perhaps grudgingly, provided to the defense that Colin Albert's name was intentionally omitted from the police reports in order to protect him. Similarly, Brian Albert is the only person listed in the initial report whose first name was not spelled out, but just listed as B. Albert. And the number of his home is misstated on various first responder reports. Not unlike the traffic report we talked about earlier, just sloppy. Because it was the folks filling out that mass trans report, it was not a big deal. It was not an incident that they thought would in any way come back to haunt them. And I really don't think it's coming into trial. But anyway, Brian Albert, the only person listed, B. Albert, these myriad mistakes are more than simply curious. They are systemic in this investigation. There appeared to be a conscious effort of investigators in this case to hide these third-party culprits. That, of course, is the thrust of the argument by the defense here. So then they go into the law that supports their right to bring a third-party culprit defense. La la la. Take a look at that if you need to. Do some research and get a paper on my desk in the morning. Let's see. Wide latitude. The bar for admissibility is generally low, and again, all doubt should be resolved in favor of admissibility. That's kind of I don't care what state you're in, federal law, state law. This is Commonwealth versus Stedman, the one that controls en masse. But that's generally the approach. And I don't know that the prosecution really believes, down deep, that they're going to keep this stuff out, but they're certainly trying to keep everything out, aren't they? That's okay. Zealous representation for the Commonwealth. Notably, none of the constraints on the admissibility of third-party culprit evidence pertain to defendants' ability to raise third-party culprit evidence or arguments as to multiple third parties, which was an argument that the prosecution intended to do. Hey, you can't point to, some other dude did it, the classic defense. So you can't bring it in at all because you're saying it could be one of these three individuals. And from the prosecution standpoint, not good enough. I'm not so sure that's the state of the law, and it's pointed out here by the defendants. More sites. Let's see which one well, this one we'll hear more about, I think. Commonwealth versus Finney, a young woman murdered in her own bed. Prosecution charged the defendant, the next door neighbor. The defendant had signed a written confession that he entered her residence while she was sleeping to take photos of her lying nude in bed. Searching for nudes, Proctor then bashed her over the head with his camera when she woke up. Defense counsel in that case pursued a third-party culprit defense, which amounted to pointing to two unidentified men in downtown Lowell, one with blood on his T-shirt, who had asked a motorist for a ride to the hospital, and an unidentified man who was the victim's roommate and was seen arguing with the victim outside her apartment. So those folks, at least in this case recitation, aren't even identified as clearly as the ones the defense identifies here as Higgins, Albert, and Albert. So I think this is going to be, this opposition's great. I mean, it's filed and it'll be taken under advisement. I guarantee you there will be no decision on this today. But it's going to be a hotly contested argument because the prosecution knows how critical this is, whether the jury believes an overall, scheme, right? Or it just breaks down the prosecution's argument. I don't know. Either way, it helps the defense. So it's a big one for them to get in, and it's a big one for the prosecution to try to keep out. So they talk about the Bowden defense. That's come up a few times. If you didn't know, this is the case, Commonwealth versus Bowden. Evidence that does not qualify as third-party culprit evidence may nonetheless be admissible as Bowden evidence. And so they're trying to use this to suggest that it relates to the inadequacy of the police investigation, and that is going to be a key defense win, they hope. They have a new expert, right? Mr. Easter, who's going to come in and say the cops are horrible, they did a horrible job, and then of course that's when Mr. Brandon said, am I supposed to bring in some Massachusetts state policemen to say that the investigation was perfect, everything was great? Yeah, do it, as Alan Jackson said, just do it, because that would be so much fun to start laying on this official police expert how badly the investigation actually went. Okay, so there it is. That's the last. That is as recent as the filing could possibly get, since it was just at 8:05, something like that this morning. So they had it ready to go. So I don't see if I do see a feed. Are we ready? Are we rolling now? I'm not hearing audio. We are. Okay, let's jump in.
Thank you. All right, so thank you. So similarly, regarding the third-party culprit argument the other day, Ms. Yanegi, I see you did file something late yesterday, so I got that. I'm just wondering if either the Commonwealth or the defendant want to be heard on that.
The Commonwealth does.
Okay, so I'll hear you, Mr. Brennan.
Your Honor asked for a proffer from the defense regarding third-party culprit. Alternatively, evidence that would be separate regarding third-party culprit aspect of Bowden. We received some information from the defense that does not distinguish whether their intention is that it applies to third-party culprit or whether it applies to a third-party culprit aspect of Bowden. Those concepts are logically and legally distinct. Regardless, when you look at the proffer by the defense, it is insufficient and inadequate for both third-party culprit and for any third-party culprit aspect of Bowden. Two different analyses, but the evidence is equally feeble for both. Relative to third-party culprit evidence, there are a number of cases that I know Your Honor is aware of that guide the standard of third-party culprit evidence. Not to iterate the law because it is clear, but there must be relevance, there must be a substantial nexus between the claims of the defense and the third-party culprit theory. They provided us 3 people that they identify as third-party culprits. It's helpful just for a quick synopsis of the history. In this case, prior to the first trial, the defense never identified a third-party culprit. At some point, the defendant herself said that they knew who the third-party culprit was, and recently, the position of the defense has shifted that they don't know and don't need to know. Now, the law accommodates specifically identifying somebody. It also accommodates general, but it has to have specificity in the complaint. There has to be a motive, an opportunity, and an intention. There has to be evidence that draws the correlation. It can't be bad character, speculative, or just putting out information that's negative towards a witness so that that can backdoor prior bad acts against a witness and be used for a different purpose. They identified one person, Colin Albert. And in their proffer, what they offer, number one, and it's important to take them separately because it shows how feeble it actually is. The first thing they say about Colin Albert is he had a feud with John O'Keefe in the weeks and months leading up to January 29, 2022. Now, other than maybe on social media or in interviews with the defendant in national broadcasts, there's no evidence of that. There is no evidence that's going to be admitted at this trial that shows there was a feud between Colin Albert and John O'Keefe. There is no evidence that there was any hostility between Colin Albert and John O'Keefe. There's no evidence of a motive to kill John O'Keefe by Colin Albert. There is no evidence of any motive, of any intention, or of any opportunity whatsoever. In fact, the evidence is that Colin Albert was not even at 34 Fairview at the time John O'Keefe arrived there on January 29, 2022. And so simply saying it is not evidence. And an attorney should not be allowed to confront a witness about an allegation that has no factual basis for them to then have to defend the accusation. The prejudice then seeps to the jury, and the Commonwealth is in the position of having to disprove a claim that had no basis to begin with. The second claim that they make regarding Colin Albert is that he had thrown beer cans in Mr. O'Keefe's bushes and told Mr. O'Keefe to F off in his face. There is no basis for those claims. There is no witness for those claims. There's no information regarding those claims. I understand there may have been a party where there was beer cans, but there was no Colin Albert. So to attribute a situation or an incident to him, the defense would need some good faith proof, actual proof, fact, that this actually happened. And there's no evidence whatsoever that Colin Albert threw beer cans in Mr. O'Keefe's bushes and told him to F off. And the reason there's no proof is because it didn't happen. So again, the defense asks for an invitation to simply cross-examine a witness, allege a prior bad act, and then the witness has to defend their honor and the government has to disprove it. That is not the cloth that third-party culprit is made from. Regarding the suggestion that there was some type of feud or tough relationship, I saw on a video that there were 2 radio personalities, and I have the clip, who spoke and met with Karen Reed. And during the conversations, at least they relayed that there was some claims about a drug issue. And according, not to the defendant, but according to the interviewers who supposedly interviewed her, they said that the story is completely false. They attribute this to Karen Reed. People are trying to make it more dramatic, like Colin would have a reason to hate John O'Keefe. That never happened, referring to some drug claim. He did not report him for anything. And so what we know is there is no history of animosity between Colin Albert and John O'Keefe. We know that there was no animosity between his family and John O'Keefe. The only event known is that at some point, Colin Albert's younger brother ran across John's lawn. Mr. O'Keefe supposedly yelled at him and then bought him candy as an apology. That's it. So we have an alleged third-party culprit, a very strong claim, with no evidence. No motive, no opportunity, not even present at the time that this alleged collision occurred. And so in that absence of evidence, it's not even feasible. Colin Albert should not be brought to the stand, attacked with acts that didn't occur, that otherwise would have no admissibility Really, it seems to be a backdoor way to tarnish his reputation and then bind him with other people the defense would like to attack to make a general suggestion that somehow this group of people are bad people. I know at the last trial, there was pictures of Colin Albert's knuckles that were scraped, and inevitably it turns out that picture, I think the exhibits were introduced at trial, was taken much later. Pictures taken before that point show that Colin Albert's knuckles on the 9th and 11th of February weren't scraped at all. So because he had scraped knuckles, subsequently, because he may have done a video that some use would maybe do and threaten somebody else, not John O'Keefe, has nothing to do with this case whatsoever. It's an attempt to introduce alleged aggression or prior bad acts, but there's no bind whatsoever. The second person that the defense would like to identify as a third-party culprit is Brian Albert. And this is some of the gross generalizations that you see with Colin Albert. No specificity, but trying to assault his general character by generally suggesting things that may or may not be accurate in just telling part of the story. They claim he didn't have a good reputation among fellow police officers. No evidence. They claim it, and even if it was so, has nothing to do with this case. Known as a bully. So rumor clearly is not admissible in a criminal case. Had a history of sucker punching officers. We don't see any specificity. We don't see any evidence. We don't see any information. We just see a general attempt at a character assassination to portray him as somebody who is either capable or a bully. Nothing relative to John O'Keefe. Nothing. They suggest, and I'm not sure what the basis for this is, that he was drinking heavily that day when he went to a funeral with Mr. Higgins and another person. It is true that he was at the hillside around 9 o'clock and was drinking around 9 o'clock. So all of this information is just general inflammatory accusations about character. They say he was a trained boxer because when he worked out, he boxed and he was engaged in charity events, some dating back to 2003. By that standard, anybody in the neighborhood who has any self-defense training, mixed martial arts, or boxer would be on the target list. The fact that he is a police officer and that he is physically fit and that he trained to protect himself doesn't make him a third-party culprit. It is this general suggestion of strength and distorted into a hopefully perceived sense of violence that it has no root at all, no root. They went as far to say he was investigated by BPD for violent conduct, but they don't give any details. If they looked, they could go online, they could investigate potentially. There is no sustained findings that are known to the Commonwealth against Brian Albert in internal affairs, none whatsoever, ever. And so to make the suggestion he was investigated by BPD for violent conduct, they provide no fact. I'll say, even though it is off base entirely, it has nothing to do with John O'Keefe. They're trying to suggest that he has a propensity for violence. And they don't do it very well because they provide no details. These are all just general accusations by the defense. In fact, I would say it's not important or admissible. You can't bolster the good character of a witness, but to simply make suggestions of bad character is not any root or tethering to this case specifically. Instead of bad character, Brian Albert was a two-time recipient of the George Hanner Award, has many, many medals of honor from the Boston Police Department, but that is not the issue. They suggest that he was involved, so they know that they have to tie him not only to the scene, but somehow to Mr. O'Keefe, and other than being at the bar that night, and Mr. O'Keefe and Miss Reed pulling in front of his property that night, there is no association between the two. They say he's present at the scene of death. By all evidence, Mr. O'Keefe died feet from the street near the flagpole in front of 34 Fairview. So that's a little bit broad. He wasn't present at the scene of the death. He wasn't there. That happened out front on the front yard near the flagpole, about 70 feet from his house. The body was found feet from his front door, arguably, okay, 70 feet, 75 feet. He admits to being home. He doesn't have to admit he was home. Now, here is another claim without any evidence whatsoever. The defense states emphatically, computer forensic data overwhelmingly establishes O'Keefe entered Albert's house. I haven't seen that evidence. Based on what? So if they're going to make an offer of proof to the court and they're going to make claims to substantiate this theory, they have to have proof of it. And in their motion, I see no proof whatsoever that overwhelmingly establishes John O'Keefe went into the Albert house. In fact, what we see is the opposite. In the past trial, numerous people were called. Every single person that was asked stated they did not see John O'Keefe enter that home. Every single person. Now, whether you believe it or not is irrelevant. What's relevant is there's nothing to the opposite. There's an absence of evidence to the opposite. In fact, the phone data and the Waze data and the GPS and all the data puts John O'Keefe at the front yard, not in the house. So if they're asking the court to make a finding of substantial link and substantial proof that John O'Keefe was in the house, they have to actually give you the facts and the science and the data to support that. And I don't expect that will happen. They add that there is going to be expert testimony that the scratch on John O'Keefe's arm was from an animal or a large dog, and because Brian Albert had a dog in the house, there is some type of inference. Dr. Russell has already testified at the Lanigan hearing that she's not saying that those bite marks were from Chloe. Although it has not been decided by the court, Dr. Crosby has done molds that show that the teeth comparison is totally an opposite. And so even the defense is not saying, as I see from the disclosures, that Chloe bit John O'Keefe. Their version, which we don't agree with, is that a large animal or a dog caused these wounds. They don't say where, they don't say when, they don't say how. And so that is not a link so that Brian Albert becomes a third-party culprit. Finally, in a way to try to create some type of traction against Brian Albert, they associate him with Brian Higgins because they spent the day together, because Brian Higgins, according to them, was rebuffed because of phone calls at night. All of these general claims with no fact predicate rely on innuendo, surmise, speculation, or just the creation of an inference that does not exist. There is no evidence Brian Albert had any motive whatsoever to harm John O'Keefe. None. There is not one witness, there's not one statement that Brian Albert had any animus whatsoever towards John O'Keefe. None. He did not have the motive. He did not have the opportunity. And there is no evidence that he was involved in any way in the alleged collision that happened in the front of his yard that night. Finally, the defense turns to Mr. Higgins. Mr. Higgins was at the Albert address that night. John O'Keefe never went into the Albert address that night. They take very, very select pieces of information, and I would suggest don't tell the whole story. And from that, they want us to speculate a motive. For example, they say that Karen Reed had kissed Mr. Higgins at John's house. That seems to be corroborated in the text messages. According to the text messages, Mr. Higgins essentially says that Ms. Reed came up to him and planted a kiss on him. And there's quite a bit of text message exchange that you heard during trial about that interaction. And then at some point, Ms. Reed went to Mr. Higgins' house. And so there was some interest, it would appear from the text messages, between the two. Mutual, at best. There's a plethora of text messages where Ms. Reed is pursuing Mr. Higgins, looking for his time, looking for his attention. In one, she says, of basically begging him to come over. Do you like me? Come over to my house. There are text messages talking about Mr. Higgins not having enough time for her. So there is a flirtatious relationship between the two of them. What we don't see is that somehow that creates a motive for Mr. Higgins to want to hurt or kill John O'Keefe. The fact that they are texting together and later that night he sends a text message because I think an inference the defense would raise is that he felt like he was ignored or wanted to know what was going on with their relationship, is not evidence of motive. In all of these text messages, you never see any animosity towards John O'Keefe. Mr. Higgins's text messages are virtually all kind towards John O'Keefe. It's uncomfortable. It's an awkward situation because both of them appear to be deceptive as it relates to John O'Keefe, but there is no vengeance, there is no anger. And so the suggestion that there is a motive because there was flirtatious text messages to then kill the man is beyond the pale. It's beyond any logical connection that would support third-party culprit. Brian Higgins sent a text message saying to John O'Keefe, asking if he was coming to the home that night, and they then attached the word he lured them to the house. I mean, we do look at this evidence not in a vacuum, but logically and realistically. Not knowing that Karen Reed was not going to come in when they arrived at the house, is it reasonable, is it rational, is it lucid to think that that Mr. Higgins was inviting them both over to the house, not knowing only one of them would get out of the car? Is the suggestion that Mr. Higgins was going to kill both of them? Or he was going to kill one of them, so the other one he would then set up for murder so that he wouldn't be able to see her anyways? The absurdity of the relationship between the claim and reality is so great that it will just run rampant through this trial. It would be unrelated, speculative, shotgun approach to claims that the witness will spend their time trying to explain and defend. It will distract the jury, and it will serve the purpose, which the case law says it shouldn't, of taking attention off the facts at issue for the case we're here from. And that attempt to divert anybody but the defendant is the attempt here. That's why we have three, we don't know who, but three potential third-party culprit evidences with absolutely fragile evidence. It's feeble. As their support, what they offer is they believe Mr. Higgins lied because he went to the Canton Police Department to do administrative work. And I think the evidence is clear that he had cars that he parked there as part of his job that he needed to clean off. So they are parsing words in an attempt to create a basis that doesn't exist. That there are calls between Mr. Albert and Mr. Higgins later that night. So what? They have no evidence that either of them spoke to each other. They have no evidence of conversations. They have no evidence of a conspiracy. They have no evidence of a cover-up. They have no evidence of a weapon. What we know is John O'Keefe never went in the home. And so to try to create this image based on obscure facts is not the substance that's required under third-party culprit. I know third-party culprit is a time-honored tradition and is a broad latitude, but it's not endless. It can't prejudice the Commonwealth. It can't distract the jury. It can't be based on fiction. It has to be based on an identifiable theory. The cases that have allowed third-party culprit that have been reported have actual people who could be a third-party culprit, who actually have relationships to the scene or the crime or the deceased. In this case, an attempt to call Mr. Higgins a liar or create fictions about what they think he could have been doing or guessing what they want him to do is not evidence. 9 people testified John never came into the house. 9 people. There is no overwhelming evidence or any evidence he went into the house. There is no evidence of motive on any of these 3 people they identified. They've had, before the last trial, the entire trial, and was aptly pointed out, no request for a third-party culprit instruction. And then they had since then to make an actual proffer that people actually have the motive, opportunity, and intent to do this, that there's actual evidence that there's this alternative theory, and they failed to do it. To have the defense go through a trial, distract the jury, attack the reputation and character of the witnesses, and then not even ask for an instruction at the end, it evidenced the fact that there is no basis for a third-party culprit. Now, separately, third-party culprit is part of Bowden. Even if the defense at the end does not warrant an instruction, I recognize that challenging a police investigation is virtually an entitlement of a defense. How they do it and the extent they can do it is a different story. Simply because they have an attack on the police investigation does not let them use third parties as part of that. And so the standard, Silva Santiago, is very clear, it's cited by almost every case, is that there has to be something the police didn't do at the time that they knew about and should have done. So at the time the police did their investigation as being criticized, they would have had to have known about a potential third-party culprit or third-party culprit evidence and didn't pursue it. And that's where the defense argument utterly fails here. Because at the time the police were doing this investigation, what they knew is that John O'Keefe was on the front lawn of 34 Fairview near the street. They knew that he was dying or is dead. And a number of witnesses knew that Miss Reed was saying, I hit him, I hit him, I hit him. A number of witnesses. Shortly thereafter, what the police knew is that Miss Reed's taillight was cracked. And shortly after, what they learned and knew after they got her car is that part of her taillight was missing. So at that time when they were doing their investigation, there was no claim of dog bites. That came months and months later. They went to 34 Fairview and they spoke to the owner, according to the witness testimony. And everything seemed appropriate. Concerned, confused, no blood, no scratches, no cover-up, no turned over furniture. There was nothing that would have alerted the police officers that there was any road to follow other than the road they followed. Now they can be criticized for plastic cups or leaf blowers, but that's different. That's different. In order to have third-party culprit under Bowden, the police would have to have known that there was information that targeted or pointed out a different person, and they didn't pursue it. So in the cases cited by both the Commonwealth and the defense, there are a number of cases that talk about information that was known to police at the time they were investigating and they failed to pursue it. That is not this case. That is not this case. There is nothing in any of these proffers that show actual evidence that the police knew of these later third-party culprit claims by the defense, or they knew at the time they were doing this investigation that there was any other lead. And likely the reason was because there wasn't. The evidence for a reasonable police officer pointed towards the statements, towards the car, towards the light, and that was followed up, which led to DNA and hair and all the other evidence that followed, the data. And so as a concession to the defense, they don't simply get to bring in third-party culprit through Bowden because they failed in the instant case to show a third-party culprit. That's not part of their entitlement. And mindful that if they do raise Bowden, whether they get an instruction or not, it is broad. And that means the police, including any police they would call in this case, or we would call, is entitled then to share their state of mind why they did not do something. That can open doors to inadmissible evidence, privileged materials. The state of mind of the officer is relevant if they make it relevant. So we should not engage in a process where we allow witnesses to be asked questions with no ability of the defense to follow up those questions with actual proof. We should not engage in a process where witnesses, their character is attacked when it has no relationship whatsoever to this crime. And witnesses shouldn't be put through the ordeal of defending themselves based on generalizations about supposedly being violent or having a temper. There needs to be that nexus, and it fails. It is beyond feeble. And so I ask Your Honor not to allow third-party culprit in the instant, and you should not allow it as part of voting.
Thank you. Yes.
Your Honor, the Commonwealth's motion raises three interconnected issues, not just two. I believe that two of those were conflated by the Commonwealth. I'd like to separate them out.
Okay.
The first issue is the introduction or admissibility of evidence relevant to show that somebody else harmed John O'Keefe. The second issue, which I think was conflated with the first, is whether after the introduction of such evidence, the defense is allowed to argue that a specific person or persons caused John O'Keefe's death. And then the third issue is whether the police properly investigated this matter in light of the information that they had or information they could have obtained or failed to follow up on to show that somebody else caused John O'Keefe's death. Regarding the first issue, which Mr. Brown spent a lot of his argument on, there is ample evidence tending to show that somebody else caused John O'Keefe's death. In our opposition, we have cataloged the evidence against each of the potential third-party culprits that we named the last time we were in court. Each one of them had a motive and an opportunity to harm John O'Keefe. The investigators in this case had evidence that pointed to Brian Albert. Brian Albert is a violent man. He was not only a boxer who punched people in the ring, he was also a violent drunk who sucker punched other police officers. Those police officers are on our witness list. He's been investigated by the liquored up. He testified to that. He was at the hillside when he had his first drink in the afternoon, and he testified under oath he was drinking consistently the entire rest of the day and night. The Commonwealth says that every single person didn't see him in the house. Those same witnesses that the Commonwealth points to, every single one of them also did not see him on the front yard where Mr. Brennan claims that he was at the relevant time period. That day and night, Brian Albert was attached at the hip to his close friend, Brian Higgins. This was the night that after having carried on a flirtation with Ms. Reed while she was dating Mr. O'Keefe, Brian Higgins was confronted with Ms. Reed and Mr. O'Keefe together. In the words of one eyewitness, Ms. Reed and Mr. O'Keefe appeared to be lovey-dovey that night. Higgins had expressed his interest, but it went nowhere. And it went nowhere because prior to January 28th of 2022, Ms. Reed had rebuffed him, essentially ghosted him. She stopped returning his messages. Brian Higgins was liquored up that night as well. They're both very large men. The court saw them on the video. Friends who drank the entire day and night, and they were waiting in the house for Mr. O'Keefe to arrive. Mr. O'Keefe ended up dead because he went to Brian Albert's house. After Brian Higgins left, Brian Albert maintained contact with him. At 2:22 in the morning, the two of them were exchanging phone calls to check in with each other just a couple of hours after Mr. O'Keefe was mortally attacked. Mr. O'Keefe had dog bites and or scratches on his arm consistent with a dog or an animal attack. Brian Albert had a large German Shepherd who had attacked and injured somebody in the past. It all fits. The Commonwealth utterly failed to investigate Brian Albert as a potential suspect. And I'm sure the court remembers the words in a text message of now ex-trooper Michael Proctor, the lead investigator who's now been fired as a result, in part, of being biased in this investigation. I would point out also that when Mr. O'Keefe was in the house, both Brian Albert and Brian Higgins were unaccounted for, according to the testimony. With regard to Michael Proctor's words, he was asked specifically if the homeowner would catch any grief for having a deceased person on his front yard, and Michael it's worth stressing that Brian Albert was a first responder. He chose to ignore his duty to help somebody in need and instead stayed in his bedroom. And Brian Albert's dog, the family dog, a member of the family for 7 years, Brian Albert got rid of the dog, shipped it to another state, only after it was made known in court that the defense was alleging that the dog had been involved in the attack on John O'Keefe. We showed photos of John O'Keefe's arm in a public hearing where it was clear to any unbiased observer that Mr. O'Keefe suffered those particular wounds from a dog or animal attack. Brian Albert responds to that allegation by essentially divorcing his family from their beloved dog, whom they had had for 7 years and certainly considered to be a member of the family. In the aftermath of John O'Keefe's death, Brian Albert went so far as to send that family member to another state. That's enough evidence to point to Brian Albert as a potential third-party culprit in this case. To end the contact. She stopped responding to him. She no longer gave him any attention. So we come to January 28th. Brian Higgins sees Ms. Reed in person, but she's not alone. She's instead with Mr. O'Keefe. Ms. Reed and Mr. O'Keefe are affectionate with each other that night, and Higgins is there to see it, as is Brian Albert. There's evidence that Mr. Higgins wants Mr. O'Keefe to come to the Albert's house that night. In fact, he appears fixated on making sure that Mr. O'Keefe went there. In the waterfall video, Your Honor, you will see that Higgins motions to Mr. O'Keefe when they're leaving. And Higgins even texts him directly after that to make sure that he was coming. Then Higgins goes to the Albert home. John O'Keefe goes inside. Higgins is there waiting for him, with both the motive and now the opportunity to hurt John O'Keefe. Like Brian Albert, there's evidence of his consciousness. Including in the first trial, that he never called anyone. We've learned since that trial that Higgins is at the station on video making a phone call. So I suppose the question is, why did he lie about that? The jury in this trial should be entitled to consider the answer to that question. And of course, the police never investigated who he was calling or what he said or who was calling him. Then he goes home and he still stays up. And at 2:22 in the morning, he's speaking by phone with Brian Albert. And he claims that they didn't, but the phone records don't lie. And this notion that these two men are somehow able to butt dial and butt answer each other is just ridiculous. And there's more consciousness of guilt evidence with regard to Higgins. When he realizes that investigators might be interested in the contents of his phone to see what evidence might be on it, he demonstrates consciousness of guilt by getting rid of his SIM card and the phone itself. And how he got rid of it was extraordinary and demonstrates just how badly he wanted to keep that information out of the hands of investigators. He admitted to breaking the SIM card into and making a special trip to a military base to put this tiny object, the size of about a thumbnail, into a large dumpster. It wasn't enough to throw it in a waste paper basket or a trash bin outside the local Dunkin' Donuts. Instead, he went through security at a military base and secretly tossed this tiny broken SIM card into a dumpster. He made sure that investigators would never know what's on his phone, and he admitted to that at the first trial. And of course, the investigators in this case, including the lead investigator, former trooper Michael Proctor, never showed any interest in Higgins' phone. Higgins nonetheless accomplished his goal of keeping the contents of the phone out of the hands of the defense in this case. That's powerful evidence of motive, intent, opportunity, and consciousness of guilt of Brian Higgins. As Mr. Brennan acknowledges, all doubt should be resolved in favor of the admission of third-party culprit evidence, linking him to the harm caused to John O'Keefe. And finally, Colin Albert is a potential suspect. He had been in a feud with John O'Keefe. He'd thrown beer cans in his bushes, told him to F off. We have a good faith basis to claim that. This is the same Colin Albert who testified under oath he had never been in a fight in his life, yet there were videos of him clearly desperate to beat up others. The same Colin Albert who had scraped up knuckles just a few weeks after John O'Keefe's death. Those knuckles looked consistent with an attack on somebody. The photographs that Mr. Brennan references that were allegedly before that photo had no metadata. We can't confirm when those were taken. Mr. Brennan wants us to just accept the testimony that they were taken before the scraped up knuckles photo. We don't buy it. We don't think a jury will buy it. When John O'Keefe was found, he had two black eyes looking like he had been punched in the face. Colin Albert was at his uncle's house with both his uncle and Brian Higgins, disliking Mr. O'Keefe for a different reason, but disliking him nonetheless. And it's suspicious that Colin Albert's name was purposefully omitted out of the police reports. There was no indication in any police report provided to the defense in the first few months of this investigation that Colin Albert was anywhere close to 34 Fairview, his uncle's house, on January 29th. In fact, there's no indication in those police reports that Colin Albert even existed. Initially, we didn't even know who he was. But we found out when we sent a letter to Mr. Lally, while the case was still pending before a grand jury, notifying the Commonwealth that Colin Albert should be called as a witness before the grand jury. It was only after we sent that letter, notifying the prosecution that we were on to Colin Albert, that testimony was elicited that Colin Albert was indeed at 34 Fairview that night. The defense caused this to be revealed, not any investigator of this case. And there's obviously an inference that his name was kept out of the police reports to protect him. The same way Brian Albert is the only person listed in the initial report whose first name is not even spelled out. He's just listed as B. Albert with an incorrect address. There appeared to be a conscious effort of these investigators to hide third-party culprits from the defense. All of these men, Brian Albert, Brian Higgins, Colin Albert, were present at 34 Fairview the night that John O'Keefe was killed, and each had a motive, intent, and opportunity to cause him harm. Now, there are many cases, Your Honor, I know the court is aware of this, endorsing the admission of third-party culprit evidence. Almost all of them allowed in a third-party culprit defense, despite a lack of evidence that the third-party culprit in those cases was actually at the scene of the crime at the relevant time. The first case cited by the prosecution, Commonwealth versus Conkey, Middlesex County case, I remember it from the 90s. It was retried in the early 2000s. In that case, a person was murdered inside a home, just like this case. Unlike this case, however, the defense could not place the third-party culprit at the home when the murder was committed. He lived down the street, and that was enough. Here we have hard evidence, irrefutable evidence, that the three potential third-party culprits were present exactly when the murder was committed. And it's notable that the defense in Conkey, in that second retrial, after the first trial conviction was reversed, the defense was allowed by the trial judge to present a third-party culprit defense, and it wasn't controversial. But the conviction was nonetheless overturned, the second conviction, on appeal, because the trial judge didn't let the defense go far enough in presenting that defense. The SJC ruled that in addition to presenting evidence of motive, intent, and opportunity, the defense in that case should have been allowed to introduce past sexual assaults of the third-party culprit, including one that took place 7 years before the murder. It was reversible error not to permit a full third-party culprit defense, including prior bad acts of the third-party culprit. And I will ask the court to consider Commonwealth versus Finney, a case that I'm very well familiar, as I previously mentioned. I brought that motion for new trial. I argued before the Supreme Judicial Court, and I tried the retrial of that case, so I know it well. The SJC affirmed Judge Ball's allowance of the motion for new trial in that case, ruling that it was ineffective assistance of counsel that the attorney did not raise a third-party culprit defense. The case law makes clear, as Mr. Brennan again acknowledges, that this defense is a time-honored method of defending against a criminal charge. The defense should be given wide latitude to present relevant evidence that somebody else committed a crime. But the main issue in Finney was whether the defense could introduce hearsay to support an already admissible third-party culprit defense. It's sort of like Conkey, where it's just assumed, yes, of course you can present a third-party culprit defense. But in Conkey, can you introduce unrelated sexual assaults from 7 years before? The answer was yes. And in Finney, of course you can present a third-party culprit defense. But can you also introduce hearsay to support that defense? It was a given, and in fact, it was reversible error that the third-party culprit defense was not brought the first time around. Mr. Brennan talks about, well, you can't do this if it prejudices the Commonwealth. That's crazy. Every single time you introduce a third-party culprit defense, you are prejudicing the Commonwealth by definition. You're not going along with their theory of the case. Mr. Brennan's aggrieved that we would deign to present this defense. And I would note, Judge, there's I believe a certain amount of gaslighting going on here in that on one side of his mouth, he talks about he wants Ms. Reed to have a fair trial. But we've spent weeks where he's just trying to knock out all our evidence, just limit everything. He's, I believe, acting more like a defense attorney than a prosecutor in that regard. But regardless, in terms of these cases, Mr. Brennan said that they all have third-party culprits who have relationships to the alleged victim and or relationships to the scene of the crime. Finney did not. In Finney, my client was the next door neighbor. My client signed a confession to the murder. The third-party culprit lived several houses away within the same city, but not close, not next door. There was no relationship other than he made statements about how the victim probably deserved what she got, and she wasn't the goody two-shoes, but there was no, that she was made up to be, but there was no, witness that put the two of them together in any way other than those hearsay statements. Nobody put him at the scene of the crime. The SJC ruled even hearsay should be admissible to support that third-party culprit defense. The defense in this case has more evidence of third-party culprits than the defense did in Finney. We're not asking this court to allow into evidence hearsay, as was admissible in Finney. We're solely seeking to introduce the crux of a third-party culprit defense, which is evidence of motive, opportunity, and means, all of which Brian Albert, Brian Higgins, and Colin Albert had. That's the nuts and bolts of a third-party culprit defense. So that's the first issue, presenting evidence of a third-party culprit defense. The second issue is whether we can argue in closing that a third-party culprit is responsible for John O'Keefe's death. That's an issue I suggest that the court does not need to decide now in advance of trial. Closing arguments come at the very end of trial. At the charge conference, this court would be in a position and would be entitled to evaluate the evidence as it came in and to make a decision at that time prior to closing arguments as to what we can argue and what we can't. And while we believe the court has enough evidence now as a result of the first trial and as a result of our proffer and our submissions and oral argument today to rule that a third-party culprit defense is permissible, but this court at a minimum should not deny argument on that issue before evaluating the evidence as it comes in. And that brings us to the final third issue, a Bowden defense. Obviously, attacking the inadequacies of a police investigation is bedrock constitutional law. It's a bedrock constitutional right. In this regard, in one sense, The discussion about the third-party culprit evidence is somewhat academic as opposed to a practical one, because all of the evidence that points to Brian Albert, Brian Higgins, and/or Colin Albert, all of it comes in to show the lack of investigation, the lack of curiosity that the police had, and the lack of investigation that they did to rule any of them out. And it comes in to show the bias of the investigators of this case. Bias is also a constitutional right. They were perfectly willing to jump to conclusions about Ms. Reed, someone outside their law enforcement circle, on the wrong side of the blue wall, but very much unwilling to be curious about whether someone within their circle had the motive, opportunity, and means to hurt John O'Keefe. Former Trooper Proctor specifically told his friends he had no interest in investigating someone connecting with law enforcement. And in their internal affairs findings, his superiors noted that his apparent bias was one of the reasons he was fired. You can't have a stronger Bowden defense than that. So I would argue, Judge, that the Commonwealth's motion really comes down to what the defense will be able to argue in this case. Our position is we should be able to point the finger of guilt at those who might have done this, but at a minimum, given that the evidence will be coming into trial anyway on the Bowden issue, the court should reserve judgment on what we would be allowed to argue from now, weeks from now, when closing arguments are upon us. This evidence, in conclusion, in our view, must come in. This is a due process constitutional right of my client, and it has to be admitted for two reasons. Number one, it's a time-honored method of defending against a criminal charge by pointing out that somebody else could have done this. And number two, it's a time-honored method of defending against the criminal charge by pointing out that police investigators failed to do their jobs correctly. We have a stronger third-party culprit evidence situation here than existed in either Conkey or Finney. And we assert it would be reversible error for this court to exclude this evidence. Unless the court has further questions, I would rest on my memorandum.
Reed. I'm going to choose to focus on case law and the facts that aren't presented by the defense. We see in their motion there's a grand claim that there's extraordinary evidence that John O'Keefe went into 34 Fairview that night. That is critical because there is no basis to accuse somebody of murdering another person if they don't have the opportunity. In other cases, a third-party culprit is not necessarily found at the scene, even in Finney. It's more than just a couple of derogatory words. In Finney, as counsel knows, there was a neighbor who had an axe or a club. He was seen with blood, went home, washed his clothes, wholly irregular. And because of this irregularity and the timing, he was then asked by his then wife about the victim, and he made a number of derogatory comments about her, showing ill will, evidencing, tangentially, motive. And so, no, a third party does not necessarily have to be at the scene at the time the police investigate, but they have to be with the deceased if they caused the death. It's obvious. And so we didn't hear any extraordinary evidence, none. We didn't hear kind of good evidence. We didn't hear any evidence. We just have the bald assertion that the data forensic evidence will show that he was in the house. It didn't. It doesn't. They don't have a proffer. So there is no opportunity to murder John O'Keefe when all the evidence points to him dying on the front lawn from an alleged collision. The defense's effort to tell a story, take a couple of facts, someone's a boxer, they drank alcohol, and convert it into a story, is how they will try to portray these unsubstantiated facts at trial. They'll tell a story. It will divert the jury's attention. So they're not entitled to it. They're not entitled to it. Time-honored tradition, yes, but there are limitations. Silva Santiago was very clear about the limitations. This latitude is not unbounded. Each of these limitations recognizes the admission of feeble third-party culprit evidence poses a risk of unfair prejudice to the Commonwealth. I'm not whining. The Commonwealth should not be unfairly prejudiced. The people of the Commonwealth should not be unfairly prejudiced because it is inevitably, it diverts jurors' attention away from the defendant on trial and onto the third party. Essentially, it requires the Commonwealth to prove beyond a reasonable doubt the third-party culprit did not commit the crime. If there was evidence of third-party culprit, the defendant should be entitled to use it. In this case, there is not. There is no motive. There is no motive. To suggest that one person was pining, although the text messages don't show that, they both stopped corresponding with each other days before. To suggest that Mr. Albert is friends with Mr. Higgins and therefore he is bootstrapped into a conspiracy to kill with no evidence. Certainly the defense can infer certain facts like getting rid of the SIM card in a way they want, and I don't begrudge that at all. There's different interpretations to it. I understand that. This was heavily considered in the federal investigation, and after that absolute thorough investigation, there were no charges. There was no evidence of third-party culprit. There were no indictments. And so, although we don't know the parameters of the federal investigation and we can only guess as to some of it, we know from what we did receive and review, it was thorough. And if there was third-party culprit evidence, we would expect that there would be a basis for it. It's not an entitlement to simply bring it in under Bowden. I don't defend that there was commentary in the officer's phone that was inappropriate. But that doesn't automatically create a situation where there is evidence that the police officers knew that there was somebody that should have been investigated. In fact, when Mr. Albert came down the stairs, the testimony is the police officer was already inside his home. There's no evidence Mr. O'Keefe, a first responder, was still outside that aid could have been rendered. That is just, it's not only speculative, it's just piecing together different facts and telling a story. So inevitably, while I recognize the case law, there are plenty of cases that talk about third-party culprit should not be admitted if inappropriate. Commonwealth v. Stedman. In that case, a person, not the defendant, was in a fight with a person at a campsite. And then later, the defendant supposedly went back to the campsite, a friend of this person, Royal, and used a knife to stab and kill him. And the defense wanted to introduce prior convictions about the fact that this supposed third-party culprit had attacked people at other homeless sites. Pretty close relationship. A person having a history of attacking people at homeless tent sites. And the court, looking at 403, did not allow it as third-party culprit. They said that the admission would be feeble, pose a risk of unfair prejudice. In that case, there was third-party culprit admitted pursuant to Bowden in a very different way. Commonwealth v. Moore. The court would not admit layered hearsay showing different identifications that were relayed by the police from third parties regarding a culprit. They said that the hearsay was uncertain, the source is unreliable, and it was inadmissible as third-party culprit. So it is not an entitlement to be third-party culprit. Commonwealth v. Buckman, 461 Mass. 2011. The defendant was charged with murdering his wife. When they received a report from one of the defendant's friends, the defendant was softly tied to a pole that looked like he had been kidnapped. Inevitably, the police determined that he had help or tied himself as a ruse. And this person, the helper, his friend, had connections to gambling, was there, and when the police couldn't find the body, he knew exactly where the body was. That case is far stronger than many. And in that case, no motive, no intent, and they did not let a third-party culprit defense go forward. Facts suggesting that one side believes a person's telling the truth or not is not facts of party culprit. It's just not here in this case. And again, I iterate my position on denying the defense to cross-examine witnesses about these generalizations and these character attacks. I think it will mislead the jury, and it will become a total diversion for the jury. And I don't think the basis is anywhere close. It's feeble.
Can I briefly respond? Thank you. First of all, Your Honor, speaking about the federal investigation when you were not a part of it, and talking about why a federal grand jury was convened, what they were investigating, what they found or didn't found, is complete speculation. It should not be a part of this argument. We don't know. It didn't prove anything. It's not as though they came up with a statement exonerating anyone. So that should not be considered by the court. With regard to the two cases that Mr. Brennan cited, you'll note that in one, he talked about the exclusion of hearsay evidence. There's a different standard when you want to introduce hearsay evidence as part of a third-party culprit defense. There need to be substantial connecting links to the crime itself. The court ruled in that case there weren't. In Finney, there were. And with regard to the other case, that's with regard to hearsay. With regard to the other case, that was the exclusion of past assaults to show that somebody was violent. Again, Commonwealth v. Conkey is a case where they said, well, that should be, in addition to a normal or a regular third-party culprit defense, you should also be entitled to that evidence. So that's not very instructive. The other two things I just wanted to point out, because I did not mention them, Your Honor, is that Brian Albert also disposed of his phone. We'll never know what was on that. That's further evidence of consciousness of guilt. And then an important point is that the plow driver, Mr. Laughlin, went by the house at 3:30 in the morning and saw a Ford Edge parked in the very area where John O'Keefe's body was found. And we know from the evidence that the Alberts, both Brian Albert and Colin Albert, owned a Ford Edge. So that is in the mix as well. And unless the court has any questions, I would yes or no.
Hi, thank you very much.
Thank you.
So let's go on to paper 620, the Commonwealth's motion for production of records regarding unsolved productions.
Yeah. May I?
Yes.
Your Honor, the Commonwealth filed a Rule 17 motion for records from unsolved productions. It has been discussed briefly in court at times during argument. There was a so-called documentary that was aired in a 5-part series. It gave a inside, behind-the-scenes look of the defense team and Ms. Reed as it prepared for the last trial. This 5-part docuseries produces a number of statements from the defendant, many of them extraordinarily relevant, some of them from the Commonwealth's perspective extraordinarily incriminating, and many of them inconsistent with statements made publicly in the past, including Dateline 2020 into Gretchen Voss. We served the local service in Boston, a local agent. The record holder is the producer of the series, and they have been notified. If the court allows this motion, I expect they will provide the information to us by the end of the week. I understand there is probably over 200 hours of recorded interviews, and we expect to use a number of those statements at trial. They are statements of the defendant, they're admissible substantively, they're admissible as admissions, and they're admissible to show contradictions with other statements. And so they are material and relevant. I understand the time frame. We haven't had the privilege of seeing them. The defense was there for a part or most of it, but we will use the time we can to sift through it. We're not looking for a continuance or additional time to look at the materials. We'll look at them as we prepare for trial. And so I'm asking you to grant this. It clearly makes the Rule 17 standard material relevant. We don't have access to these before trial. We won't be able to prepare for them if we get them pursuant to a trial subpoena. They've been properly subpoenaed and they're forthcoming with a court order.
There's no one here from Unsolved Productions opposed to this.
There is not.
Defense want to be heard on?
Your Honor, we're aware of the communications back and forth between the Commonwealth and the production company. So we've not been privy to that. This is the first we're hearing of any communications that they've had with the production company. I think obviously in an abundance of caution, they should be given an opportunity to oppose if they wish. Nothing officially been filed one way or the other. So we're not in a position to argue on their behalf.
All right. So, we have two things left to discuss. I want to talk about jury impanelment. We also have a Commonwealth motion regarding Mr. Yannetti's. Mr. Yannetti, it's 12:10. Which one do you want to go forward on first? Do you want to talk about the impanelment, or do you want this motion?
I'm not going to leave you with those.
I understand, but do you have a preference what's done before lunch? All right, so let's do that motion. Commonwealth's motion to compel communications between the defendant and attorney. Still looking at the defendant's.
Your Honor, so I'm clear, the Commonwealth is not seeking all communications between Ms. Reed and Mr. Yannetti. We're only requesting the communications that may be on any type of records in the possession of the Commonwealth. And specifically, there are phone records which have been redacted, and I do not know what is underneath those redactions. And we believe we have an entitlement to the information in the narrow area where Ms. Reed has waived her attorney-client privilege. Specifically, where the defendant intentionally divulged the content of her communications with Attorney Yannetti about liability and potentially striking John O'Keefe with her car. Those subject areas in that narrow time frame are no longer privileged because they're now public. The Commonwealth has identified a very narrow window, and that's a 3-day period. And that is what is mentioned by Ms. Reed in her public statements, that she spoke to Mr. Yannetti and she thought about it for 3 days. We're not looking for any information beyond what has been waived. We're not looking for any information on collateral issues, and that's why we suggest that the court look at those records in camera, and the court makes the assessment whether or not the area where Ms. Reed waived her attorney-client privilege, whether any of those materials would similarly be waived because they are exactly related. This is made in good faith. Anything that is non-privileged is open to the public. It's not confidential. There are 2 communications that Ms. Reed made publicly that we assert waived the attorney-client privilege as it relates to that issue. Ms. Reed had an interview with Gretchen Voss on June 20th, 2023, and the transcript is page 105, line 23. She was asked the question by Ms. Voss, "You never said, 'Did I hit him?' I hit him." And the answer by Ms. Reed was, "I said, did I hit him? Question mark. And then, when I talked to David, now this is later, David said, 'Karen, if you incapacitated him in any way, there's culpability there.' And I thought, all right, maybe this is maybe I said to my mother, just to go forward for a second, they were asking me, what was it like? Did they come out? What was the house like?" Similarly, in the documentary series, Ms. Reed is video and audio taped, and it was presented on television that she said, and then when I hired David Yannetti, I asked him those questions the night of January 29th, like, David, what if, I don't know, what if I ran his foot over, or what if I clipped him in the knee and he passed out or went to care for himself and he threw up or passed out? And David said, yeah, then you have some element of culpability. So that's how I thought about it for about 3 days. And so that is where I get the time period regarding these relevant statements, admissions by the defendant about her state of mind and her interaction with John O'Keefe and her vehicle. These statements were made during conversations that are obviously no longer protected or private or privileged. They're no longer confidential because they've been intentionally disseminated to the public. And so the defendant has voluntarily waived that privilege as to these communications in this subject area in that time period. And the key, Your Honor, is that it is the defendant herself who made the communications confidential. Even if it was inadvertent or overheard, it would still waive the privilege. This is entirely different. There can be no doubt that there was an intention to pierce that attorney-client privilege for whatever benefit the defense thought it gained them. If this was intentional, it wasn't secretive, it wasn't overheard, it was a exacting and purposeful engagement. So we ask you to review the cell phone extraction, any texts or emails that may be on those extractions, and relative to that short window, relative to this specific area, anything that is waived that is no longer confidential, we believe we're entitled to. It's obviously would be relevant if it's narrowly related to these statements, and we would use that at trial. Thank you.
I am, Your Honor. May it please the court. The Commonwealth concedes throughout its motion, as it must, that the communications it seeks to intrude into are privileged communications between Ms. Reed and her attorney, Mr. Yannetti. 2 of the 3 instances of the communication they cite to are over 9 months old, and that's in 5 months old respectively. So you have 9 months ago the Gretchen Voss statements, and 5 months ago the Vanity Fair statements. But they waited until less than 2 weeks before the start of the trial to bring this momentous and potentially far-reaching and consequential motion. Why? The courts are clear that they take an extraordinarily dim view of parties waiting until moments before trial to raise significant issues like privileged communications this close to trial. The Commonwealth does not explain their delay in raising this issue this close to trial. With regard to the 3rd communication, the HBO Max one, it regards the same event that is discussed in the first 2. There is no addition of an event in the 3rd one. So that 3rd discussion, the docuseries, regards the same events that have been extant in the first 2 that have been extant for 9 months and 5 months. The depth of this attempted intrusion by the Commonwealth should disturb and unsettle every citizen of this Commonwealth, because they're either actual or potential clients of lawyers, and it should unsettle every criminal defense attorney in this Commonwealth, and I would dare to say it probably does. As we know, texts, emails, and written communications, exactly what the Commonwealth is seeking here, between an attorney and their client, are canonical examples of privileged material. So what is at stake in this motion? What is at stake is the sacrosanct attorney-client privilege. In Upjohn versus United States, the really bedrock attorney-client case from the U.S. Supreme Court, it established that dating at least from the age of Shakespeare, the attorney-client privilege is the oldest of privilege for confidential communications known to the common law. And this Commonwealth has identified that it is one of the most important, and it's been recognized in the Commonwealth as early as 1831. And in the context of criminal circumstances, the privilege has constitutional dimensions as well as it affects the interests of justice analysis that is documented in the Commonwealth v. Golden case 395 Mass at 502. And it bears underscoring the basis and the depth of the intrusion is a quote from the very case and the only case that the Commonwealth cites in its motion. It cites one case in its motion for all of its propositions, just one. Matter of a John Doe grand jury investigation, 408 Mass 480. In the case at 485 states, as we have indicated, extraordinarily high value must be placed on the right of every citizen to obtain the thoughtful advice of a fully informed attorney concerning legal matters. A rule that would permit or require an attorney to disclose information given to him or her by a client in confidence, even though such disclosure might be limited to the period after the client's death, would in many instances, we fear, so deter the client from telling all as to seriously impair the attorney's ability to function effectively. We think that the potential is inconsistent with the traditional value our society has assigned. Here's a key point. In the interests of justice, and that's the rooting of the interest of justice analysis, to the right to counsel and to an effective attorney-client relationship. Therefore, except where mandated by constitutional considerations, and it cites the Commonwealth v. Goldman, Super 395 Mass at 502, which are not a factor in this case, nor are they a factor in our, not a factor in that case. We conclude that the attorney-client privilege should not yield either before or after the client's death to society's interest as legitimate as we recognize that interest in obtaining every man's evidence. So the case the Commonwealth cites supports the protection of the attorney-client privilege. With that law jurisprudential predicate in mind, I now turn to the statements at issue here and their import to that analysis.
You know what, Mr. Leslie, I'm going to stop you. I understand the Commonwealth's argument regarding waiver. I understand that the request is narrowly tailored. I'm not going to give you this information, Mr. Brennan. I don't even think it's appropriate for me to ask, so the motion is denied.
Thank you, Your Honor.
So we need to talk about the panel. The parties need 5 minutes.
All right, so go please.
It's like a movie premiere. This got dropped off right in front. This might be the new protocol. They're right on the corner. Normally they're across the street, and they have somebody walking through the crosswalk.
Ask Alan Jackson how the Lakers are doing.
Hey, how the Lakers doing, Alan? I haven't kept up with them. Oh my goodness. Okay, yeah. I don't know.
Doing well?
Mike, how they doing? Anybody?
Or am I just not hearing?
You guys got a new guy, though, right?
Not so good.
Not so good. Not so good. Okay.
I know they've got a heck of a new player.
Yeah, the new guy, right?
Yeah. He's supposed to be the best in the league.
Yeah, Luka Dovic. Luka.
Like a
We
lovely
can't talk
debate.
about the case. We just got to ask him random questions.
Oh, they were
Ask him what kind of suit he's wearing.
Okay, so that almost
A nice one.
further away
Yeah.
than usual.
Hey, SD, why I love us more.
You allowing us to use some video here. We appreciate that.
I get your phone call.
That's Jack. Stay off your phone.
Another way. Let's go. No, I'm keeping it small today.
Yeah. Here we go. Here we go.
All right. One up there. Hi, Jill. Man.
Hey, there goes Dina. Saw that. Although she didn't have her glasses.
Are the state police being extra nasty today or what?
What?
Are the state police being nice today?
The guy just picked me up and moved me.
Okay.
As nice as he could, we'll say.
All right. I still
So we
want
haven't
to
heard
get
yet
two
about
hands, you know what I mean?
Oh, he had.
What was it? 500 feet was asked for. Last time it was 200 feet. The judge wanted to look at some of the information. I guess the merchants or merchants association sent a letter saying we're getting totally disrupted, and I think it focused on a market of some sort, like a farmer's market, which sometimes, especially smaller communities, and this is like 25,000 folks in Canton, probably a few more in Dedham, but still, they do them during the week sometimes, right after the lunch hour. So yeah, I could see how that would be. That could be kind of a mess. Yeah. So we'll see if they rule on that, along with other things. Is that it? Is that all we've got on the video there? Is that the end of that? I guess it is. All right then. All right then. So, okay, first of all, I had to check and make sure that Judge Bev was actually the one on the bench, because I may be wrong. I believe she ruled on a motion. You get that? Yeah. In fact, she, when she cut off Alessi, and we're used to her cutting off the defense in the middle of arguments, I assumed it was bad, that it was probably, because she was ruling against them. But again, this was the Commonwealth's motion to compel the communications between the defendant and Attorney Yannetti. They were looking for that specific time period between the 29th of January, 2022, and February 2nd, 2022. That was the period in which Karen Reed said to Yannetti that, hey, I don't know what happened. Maybe I bumped him. Maybe I hit his knee. And Yannetti responded that, well, if you did any of those things, there could be some culpability. That was the end of that. Anyway, that was denied. So Alessi's argument was, whether it was persuasive or she had already decided this, I don't know. But he referenced that it was 9 months ago with the Gretchen Voss interview. That was for Boston Magazine. It was 5 months ago for the Vanity Fair article. And now, only because this ID program, which he called the HBO Max program, because that's where it's being sent for on-demand viewing, but it was originally on ID. He said that's the only reason they're even bringing it up now, and yet there's nothing new in that production. So, oh, here, this was fun. And I noticed a couple of chatters mentioned it. The word is canonical. That is canonical. He's a smart dude, Alessi, and so he throws out the big words every now and then. That of course just means related to a canon, a rule, something. Kind of a nice word. Not as nice as the word that I'm sure the defense was happy to hear when denied was the Commonwealth's motion to compel that communication. So it's an interesting insight maybe into how Judge Bev is looking at this particular issue, because we know how it has slopped over into the Aiden Carney messaging back and forth between Karen Reed, and whether there's some consciousness of guilt as a result of that. Remember, we're going to have Aiden on tomorrow night. Is it tomorrow night? Yeah, tomorrow night at 8 o'clock, Wednesday night, 8 o'clock. Of course, we'll have those notes sent out. While I'm doing some programming notes, Friday we'll have Doug Weinstein on. Now, he's got one or two things going on. Obviously, Yak Gandhi's attorney in YSL. That trial ended with a complete exoneration and acquittal for his client. So he's on to other stuff. He hadn't really been following the Karen Reed case, but he posted something the other day that made it clear that even if you're not trying to follow this case, you kind of get sucked into it. And so we want to get his take on the Karen Reed case and see what else he's got up to. Again, that'll be Friday at 5 o'clock live. We'll do that. And then at 6, I think we're hopping over to Will, the Glarer, and Linda and I will be visiting with Will on Friday night after we do the Doug Weinstein. Okay, so let's see what else they talked about before an actual ruling came down. And they're just taking a break now. She said 5 minutes. I've never seen a court 5-minute break, so I'm assuming it's a touch longer. Linda is en route back from her assignment, her attorney work, and so she'll join at lunchtime, or if we have any other breaks between now and then. So one of the first motions that they brought up was the one we were just talking about. I felt like we had just made the argument at trial. It was the motion by the Commonwealth to preclude any third-party culprit argument, and the defense filed just this morning their opposition to that. And again, this was taken under advisement, hasn't happened, and what a surprise! This is big, and a lot of people are maybe saying, "What's the big deal?" It's going to come down to whether or not this jury thinks there was something else going on, or whether they can point to a third party more specifically, which is what the defense wants to do. It's not going to be that big a deal. I don't know. I think it is kind of a big deal, because it really opens up what you can and can't talk about as to what is believed to have been going on in the house that night. It's going to lead to portions of testimony with these various witnesses, Jen McCabe, Brian Albert, all these guys, where you can catch them in contradictions based on what may or may not have happened that night, because there was no thorough investigation that night. Nobody really went into the house and checked it out that night. And so that could lead to some inconsistencies, because the truth never changes, but sometimes if you're making stuff up, it can change. So they talked about, boldly, Hank Brennan says, John O'Keefe, he never went in the house. He was never in the house. Stating it as a matter of fact, as if all of the evidence that was presented in trial number 1 was so conclusive that it's not even a dispute. Officer John O'Keefe never went in the house, period. Let's move on. No evidence that Colin Albert, who the defense claims was sanitized from any police report, not mentioned anywhere. Their belief is he was in the house. He was definitely there. The position of the Commonwealth is there's no evidence of that. There's no evidence. So that was a big point they were trying to make. And then they also talked about the kiss. Remember the kiss? The whole defense argument, and they brought this up in their opposition, was that there was this, I guess, flirtatiousness that began with Brian Higgins and Karen Reed, and then she poo-pooed him. For whatever reason, it didn't progress beyond this alleged kiss, and that somehow Brian Higgins was so upset about that he wanted to get back at Officer John O'Keefe, because, I don't know, I guess if you look at it in the rawest sense, that he won. John O'Keefe won Karen Reed, and that pissed off Brian Higgins. That's, if you take a step back, that's the measuring stick for any motive that might have existed for Brian Higgins to hook up with Brian Albert and Colin Albert to go after Officer John O'Keefe. And then Chloe, of course, took part as well, because she doesn't do well with strangers. That's the reference that we saw in the motion. Let's see. And so Brennan just goes on and on to talk about how the information provided in this opposition is just, it's too thin, beyond the pale. It's beyond the pale. It's what he said. He believes that their suggestion that John O'Keefe was ordered, to 34 Fairview by the Higgins-Albert contingent is just ridiculous. They were giving an address to John O'Keefe, and there was a follow-up text about, are you still going? That, according to the Commonwealth, doesn't rise to the level of ordering somebody there. I would agree with that, but doesn't mean they weren't suggesting he show up there because they had some reason to confront him. Doesn't really answer that question. I don't think it was rising, though, to the level of ordering him there, as the defense might suggest. And so they just pounded away on nothing. He never went in the house, period. To them, that's the end all be all. He did not go into the house. So the defense gets up, and Unetti argues this, again, in favor of the motion opposition that was just filed today, and believes that there, importantly, is this violent history that Brian Albert had, that he had a history of beating up cops, that they're going to call, the defense is going to call fellow officers who have, I guess, been subjected to a Brian Albert beating or at least some sort of physical altercation. They're saying they're bringing those folks on to show the violent nature of Brian Albert. Now, you're going to have some big issues with character evidence, trying to keep that out. It's not, you can't have generally evidence of bad character. Somebody's bad character at a prior time does not necessarily mean they had bad character and or violent nature at the time of the incident. So it's tough. It's tough to get that one in. You have to develop a pattern. And if you can get beyond that, the pattern evidence, then maybe it comes in to establish that he is in fact a violent person who has many, many, many altercations in the past. So we'll see who he brings in and who he doesn't. He says Higgins and Brian Albert were connected at the hip, so they somehow had kind of conspired to deal with Mr. John O'Keefe that night. Let's see. They talk about Proctor being fired, which of course is going to be very interesting. The Commonwealth is concerned that Proctor's investigation, now terminated because he's been terminated, is going to slop over on them at this trial. I can't imagine how it doesn't. We've been speculating, is the Commonwealth going to call him, or is the defense going to have to do that part of the dirty work and lay the whole story out? I have to believe the prosecution will do what they can. They know he's coming in. So if you know it's happening, why don't you bring him on? Why don't you try to diffuse as best you can this really slimy witness? Okay, looks like we're back at it. Let's see if the judge has made any decisions, and if not, where we're going for the next motion. Stay where you are.
I don't like the two questions in a row, 4 and 5.
You getting some audio? And you never know if it's the feed or not. So hang with us here.
So that's out.
We had some technical difficulties as well on the long crime feed, but it seemed to have cleared up. So far, no audio in this particular moment. Somebody may need to flip a switch at the court to feed there.
Do you believe law enforcement officers are generally fair and accurate in their
Well, I don't read lips very well, so I can't tell what you're doing.
All right, so I don't have a problem with that, but it makes sense that we put it after 8. Those series of questions.
Curious.
No objection to that.
It looks like Elizabeth Little is making some sort of argument. We looked at that jury questionnaire yesterday where the third page was effectively added by Elizabeth Little, and it has to do with all the publicity in this case. Hoping to ferret out jurors who have been, I guess, convinced or who've taken part in some sort of publicity about the case that might affect their ability to be, fair and impartial.
All right, so you can suggest something at some point.
I don't hear the white noise either, so I don't know if we're just not getting audio in general, or if the court has not yet allowed it to be turned on. There's definitely some activity. Something's happening.
The defense when it was removed, I guess. Is there anything about crash reconstruction testimony that would make it difficult for you to be fair and impartial in this case? I don't have a problem with that question. Does the defense?
Okay. Silent movies. I love them.
It just wasn't a particularly useful question. We thought the last trial, everyone said no. So And further, to trying to have additional space for more multiple questions, we just decided to exclude it.
All right, I think we'll keep it.
There was a couple of things that Yannetti mentioned as he was wrapping up his arguments against the motion to prevent any third-party culpability. First of all, he said the issue about whether or not it would be allowed.
23 on the defense. Does the Commonwealth object to that question? I think it needs to be tweaked at the least, just a little.
We do.
All right, so what's the objection?
I think the question, the way it's written, invites a juror to potentially not follow the judge's instruction. And so I understand the attempt, the idea of it, the germ of it, but the way it's written, it invites, I think, a jury to, or a juror to usurp what their role is.
And what do you say, Ms. Little?
I think if we just tweak the language a bit, I mean, we're happy to hear some proposals from the DA as to sort of the particular issue they have with this question. But I do think a question about the judge's instruction regarding, you know, you're entitled to your own independent individual verdicts.
So they're always told that their verdict must be their own. So there's language in there's probably language in my preliminary instructions, there's language in the charge, certainly. So if it mirrors that language, I don't have a problem with it. Otherwise, I might. So
we can mirror the
talk to each other.
The court's charge.
All right. So
We would agree to that as well.
okay, thank you. Number 25 in the minutes. If you had to vote today on whether Ms. Reed is guilty or not guilty of the crime charged, what would your vote be? I tell them throughout the trial, they're not to speculate, they're not to make up their minds until all the evidence is in. I'm not going to even suggest that this is appropriate. So I'm not going to include that. There are enough questions on reasonable doubt, presumption of innocence, and defendant not testifying. So that's out. So the question, also, is there any reason why you do or do not want to serve on this jury? I don't think we should invite them to decide whether they want to sit in this jury or not. I think we did give this last time. I don't know what the responses were. Does anybody have any information on that for me?
I think most of them were no. I think 27 kind of hits the same sort of, if
Right,
you have
if that-
more concerns about the case, so I don't have a strong objection.
If that's what we're getting at, we've got it in 27. So I'm inclined not to put it on there. Again, I can hear from you beforehand, probably in writing, I don't want to bring it back.
May I alert the court's attention, there's two on the first page that were slightly worded differently in the Commonwealth's proposed questionnaire and the defendant's
Oh, okay, which
proposed
numbers?
questionnaire. If the court looks at number 4 on the defendant's questionnaire, we had kind of combined the Commonwealth's proposed questions 4 and 5.
Yeah.
So that's one question.
So that's, and I just got rid of Commonwealth 5.
Perfect.
So this one's better, so we will use that.
Okay, and then number 7 that was proposed by the defense, that is the same, similar question as number 8 in the Commonwealth's proposed questionnaire.
Yes.
It's just different language.
I thought it was the same.
So we changed it to say, we tend to believe or disbelieve law enforcement officers, firefighters, or first responders more than a civilian witness simply because of their occupation, as opposed to automatically believe.
So we typically ask the automatically, what's the Commonwealth's position on this?
I have a strong preference, I'll defer to the court.
All right, so I will think about that, Ms. Hamel.
Thank you, Your Honor.
All right, so the question that I don't like, and you may remember, causes a lot of jurors to say, I have no idea what you're talking about. 21 on the Commonwealth, 20 on the defense. So you may find a defendant guilty based on circumstantial evidence, but you cannot find a defendant guilty based on speculation, guesswork, or surmise. Is it difficult for you to understand the difference between circumstantial evidence, speculation, guesswork, and surmise?
I'm sorry, can you repeat that?
It's your number 20. I'm not going to read it again. It caused a lot of trouble before. I think in every single one I had to repeat myself. with the instruction that I gave in anticipation of this. I gave them a pre-charge on circumstantial evidence and not being able.
Yes, just the way that it's phrased in the Commonwealth's questionnaire makes it seem, it makes it seem that the Commonwealth doesn't have to meet their burden of proof.
I think it should be omitted completely.
I have no issue with that, it's just the way that it's phrased in the Commonwealth's questionnaire.
It's just confusing in my mind.
Okay, they took out, if you remember, it took out an inordinate amount of time, virtually every single juror.
We have no problem with that.
All right, so that will be omitted. All right, so that's that. Ms. McLaughlin, I think you said, and I think I cut you off the other day, that the third page was right from Chisholm. I reread Chisholm on 95 pages of it the other day, and I didn't see it. Where does this third page come from? The publicity one.
The questions come from Chisholm that were asked in the juror questionnaire. The other, some of the other cases, questions were part of the juror questionnaire in the prior trial that just moved over to this page. So this page dealt with a questionnaire exclusively about publicity.
Okay. All right. I think that we all know many, if not most, and perhaps all potential jurors have heard about this case. Giving them the opportunity to write the details that they were called down may take an awful lot of time and space that we don't have on this form, and frankly, I don't think we have. So what are your positions on, what's your position on 3?
Here, if I may, I can just hand up the excerpt from the Chisholm case that outlines the.
All right, I'm not sure 2 lines are enough space for it, frankly. All right, I guess we'll see what we can do. I didn't realize it came directly, same language. Okay, looks like we're giving this third page of the questionnaire. Yes, Mr.
Your Honor, I want to bring the court's attention something about the court and counsel just discussed question number 7. Could I ask the court to direct its attention to
All right,
question?
which page?
Sorry,
Current page or previous page?
the defendant's questionnaire on the first page. That was the question. I think the court's going to consider whether to use the word automatic or tend to.
Yeah.
I believe that should be broken into 2 questions. It doesn't tell us anything. For instance, the way it's written in the disjunctive, would you tend to believe or disbelieve law enforcement officers, firefighters, first responders more than civilian witnesses just simply because of their occupation? If someone says yes, we don't know if that's believe or tend to disbelieve. So I think if we just break it into 2 questions and now we've got the space to do it, that would be more instructive.
Why does it matter if it's an automatic belief?
I'm not worried about the automatic part. It's the believe or disbelieve. That's the part that doesn't help us.
Right, so if it's automatic, simply because of a person's occupation, this juror would automatically either believe or automatically disbelieve. How does it make that person a juror? Why do you need it?
Because that tells us, it would instruct me at least, it would enlighten me on how to further question that juror. If someone says, well, I'd automatically disbelieve police officers, or I'd automatically believe police officers. Those are 2 very different mindsets.
So I understand that. I'll consider it. I think we keep it as 1, and then if they say yes, we inquire.
Okay.
Maybe. Let me see.
Okay. Thank you.
All right, so it looks like we have the third page as well. I think, I have the statutory questions that I would ask of the Nayari. If we take that question that Mr. Jackson just talked about, I can ask each individual juror, if I use the tend language, if the testimony were in conflict, would you tend to believe the testimony of a police officer more than any other witness simply because he or she is a police officer? And then conversely, would you tend to disbelieve a police officer simply because he or she is a police officer? I typically do that at sidebar in every case, asked exactly like that. So It makes more sense to me that we do it that way rather than a questionnaire, but if you want another questionnaire, we'll stand as is. So what's your thought, Ms. Linda?
That would be the fitness preference.
Do you care, Mr. Brennan?
We prefer a questionnaire.
All right, so I'll think about it, I'll do it one way or the other, and you'll know next week. So one of the things that I was considering doing, so we have a lot of jurors coming in next week. On Tuesday, 218 jurors have been summoned, is my understanding. We will get some portion of that, we will get some fraction of that maybe, just on how it goes with whether people are here and available to testify on that date, to serve as jurors. So say we get like 150 or 175 jurors. I have my remarks to sort of just direct them to what their job is, as you remember, and then I leave and I give them the questionnaires. My guess is for the jurors to fill out this questionnaire, have the questionnaires collected and copied, might take an hour and a half or 2 hours if we have a really large number of people. What I intend to do, at least on Tuesday, is have all the jurors fill out the questionnaire, however long it takes. And depending on how many jurors we have and what time it is, maybe take 50 of the last jurors or so, send them home and have them come back the next day at 11 o'clock. If we've got fantastic court security here, hopefully we've got a courtroom to keep people in. There are a lot of things we have to juggle to get this done, and I don't want to waste jurors' time. So I would send them home, have them come back the next day at like 11, so that then the next day's jurors at 11 o'clock can spend that hour and a half, 2 hour process, filling out the forms, having a copy given to counsel, and we can continue on with those jurors. So it's something we can decide on Tuesday when we see how many people are here, how many jurors we get, how many jurors the district court needs. But is that a process that you would be willing to do? Mr. Brennan?
Of course, no objection.
All right, so we'll try and figure out something that way to get things moving that way. All right, the list of witnesses, you both have a list of witnesses. I told you you needed to combine them so that I can read that to the jury and the statement of the case to the jury. Do you have that yet?
No. We have not combined them.
All right, so I need you to look at that, and a statement of the case to read to the jurors. It's all part of the final trial conference. So I should have had it last week. So I need that by Thursday. Is there anything else we need to discuss today?
There's still a few outstanding issues. One is ARPA. And
Where do
so,
you stand with discovery on that?
we received some two letters last night. It is not the information I was seeking from my motion that was allowed by the court. And so I have great concerns about waiting for the day before their testimony to pursue the other discovery that I've been entitled to.
What do you say, Mr. Jackson? Mr. Jackson?
Your Honor, I do not know what Mr. Brennan is referring to with regard to what he's looking for and great concerns. The hyperbole is unnecessary.
So there was a motion allowed, so that should be able to, there was a motion for the discovery allowed a while back.
It
So
was.
that should narrow,
Right.
right?
Pardon me?
That should narrow things.
It does, and we have not, I attempted to confer this morning with Mr. Brennan, and my recommendation to the court would be for us to confer further, because I just don't understand what he thinks is out there, but we haven't conferred fully either.
Okay, all right, so do that, we can address this next week. People going to have plenty of time to sort of tie up loose ends during the impanelment process, because I think it's going to take a very long time to get a jury.
Understood. And I expect we'll file a response to a proposed expert who received a report last night. And I didn't receive it until later, which I want to have a chance to respond to.
And Your Honor, if I could, please, one more item when it's appropriate for Your Honor.
That's okay, go ahead.
Thank you. We did receive the, Your Honor may recall the argument over Dr. Welcher in Your Honor's direction request, and then the assent of the Commonwealth that they would redo what they had provided, that 140 slide presentation. We did receive that, but we received a lot of other material in addition to that, huge megabytes. I haven't even been able to open it up. It takes so long to open it up. I respectfully request that we, Your Honor, grant us please 2 more days than what we had to take a look at that, because it's just taken an extraordinary amount of time.
Okay, makes sense, Mr. Berman?
I can be clear, there's no new information. What Mr. Welch did is that all the information he based each of his opinions on was in the gigabytes we provided to the defense, but he wanted to make it as seamless as possible, so to effectively hold their hand through it. He put each site under each slide so they can find it in the file folders exactly where it is. So it's instructive and helpful, but it's not new.
Your Honor, if I may, I don't disagree with Mr. Brennan's characterization. However, it is still 140 slides or so. I was expecting a rather substantial narrowing. So what we have to do is we have to go, and unfortunately, I think Your Honor is going to hear similar points that we made, but it's going to take more time, because I had the expectation, maybe unreasonably so, that it would be a narrowed slide presentation. So I'd appreciate the 2 extra days.
All right, so when does that put us at? What was the time frame originally?
I'm sorry, Your Honor, I don't have the specific date handy right now.
The time frame as far as the response?
Yes.
Well, we were supposed to exchange discovery yesterday. And so I had that presentation sent over last night. They sent over the 2 letters, and I received the third dog experts report.
If I could, Your Honor, I maybe Attorney Brennan misunderstood the question. He is correct that he provided us with the presentation last night, but the question, I believe, Your Honor, was when was our time? Because Your Honor had given us time to respond, and I apologize, I don't have that date, but what I'm just asking for is 2 more days. Your Honor, but
I don't think I gave it to you.
yeah, okay.
So you have 2 days to respond to that.
I have 2 days from today.
Yes.
Okay.
All right. So there are a few matters outstanding. I will have the decision on the motion to dismiss, should by the end of the day, buffer zone, probably by the end of the day. And I'll get everything else done as quickly as possible. All right. Anything else?
The only other thing is the logistical issue as it pertains to both the voir dire process as well as during the trial. I wanted to ask the court if there was a mechanism by which Ms. Reed could have at counsel table some sort of an earpiece or headphones or something that's slaved to a microphone up at the bench at sidebar so that she can listen in on both. It's very, I want to avoid that if possible. It's clunky. Especially during the voir dire process. I think it would be uncomfortable, and quite frankly, I think it would be a little inappropriate to have jurors with Ms. Reed standing right there with them and with us.
It's done all the time.
It makes sense all the time.
It may be something you're choosing not to do, but she has every right to be there at sidebar. So you say you don't want that, you want accommodation. I don't know if we can do it. I'll think about it.
We could. Well, one of the things that we were talking about is potentially a closed circuit wireless microphone up the bench and a set of headphones here that she can listen in.
Put it all in writing. I would like to have had it before today. We're going to be moving around courtrooms. It may not be able to happen.
Okay.
All right, so the alternative is she can come to sidebar for any sidebar discussion, impanelment, whatever. It's her absolute right. If she chooses not to do so, I'm going to need you to tell me that.
I'll put something in writing and perhaps I've got a plan in the back of my head. I'll put it in writing. And
We have a lot of different equipment that we need to make sure has priority. It's in the courthouse, so I'm not very hopeful that we can accomplish this in the next few days.
Okay, well, Thank you for entertaining.
All right. One thing, when we get the juror questionnaires, the supplemental juror questionnaires that we talked about, and I need you both know what our decision is here, other than the 10-2 versus automatic. Let's go with 10-2. And I can either do that inside or in the form. What I'd like you to consider, and lawyers have done this in other cases that I've had, is if there are answers that are clearly what you believe would both sides agree jurors excused for cause. In an effort to be able to go through this vast amount of jurors that the jury commissioner's office was kind enough to summons in for us, if things stand out to you, it would be ideal if you could agree that jurors number 8, 12, and 16, both sides agree should be excused for cause based on the supplemental questionnaires. It would be very helpful if we could do that, and maybe keep a running sheet that would be a joint proposal to excuse these jurors for cause. It may happen when you look through the questionnaires on folks that we sent home to have them come back the next day, to just call 5 people, the court officers call them and tell them not to come in based on the questionnaires. So please think about that. It makes sense to me. It was very helpful when lawyers were able to get along well enough to do that in the case that we tried, that we had changed venues on, because of the pre-trial history also. All right, anything else?
No, thank you.
Your Honor, there was a motion for reconsideration that was filed with regard to the metadata underlying. I can.
You can make an objection. Go ahead.
I just wanted to make sure that the court saw that motion and that it was filed. I don't know if the court wants to hear a oral argument, I'm happy to do that, but we just wanted to make sure that that gets decided.
Okay. All right, there's still a few outstanding.
Thank you.
All right, anything else?
Nothing to say.
All right, we'll see you on Tuesday.
Court, all right, please.
All right, then. Where's the Tubi? I see Tubi is lurking. Is Tubi gonna?
I'm trying to
Tubi
get
gonna
there.
make an
Yes.
appearance?
Hi, Tubi's on my avatar. Hi, Michael, Brett, Jay, Brian. Woohoo! Boy, did
Ooh,
you have
man.
a morning, man. I was in a yellow taxi cab, and I wasn't sure I was hearing what I was hearing, but I know you're going to break it all down for
Well,
us.
we've talked a bit
Good
about it.
morning.
Let me get your high points. What was other than a ruling actually happening from the bench? What was
Well,
some of
that was
your-
a high point. That was, and I missed it in a second because I couldn't believe it happened. I was actually, as you know, I was out this morning, had other meetings I had to go to. You were nice enough to man Just to Serve TV for everybody that's watching. We said we'd be on, and I was like, I think I texted at one point like, "What's happening?" Blah blah blah, and then our producer said to me, "Don't want you to miss this one, even though you're traveling." And that was Judge Beverly Cannoni ruling on the issue of the attorney-client privilege. And I thought that was such an important matter that perhaps the defense should have gotten the Bar Association involved, right? And in the middle of Mr. Alessi's argument, Robert Alessi's argument, she denied the Commonwealth's motion. I was like, it went so fast, I missed it.
I know. As I was saying, my first reaction was, "What is she doing?" She's interrupting the defense as she's done so many times. But then it was like, what? You first you ruled from the bench, and you ruled effectively in the defense favor. So it was. Bev's got. I mean, Judge Bev has a surprise every now and then for.
Well, the one thing about it is that it is. I am sure that she must have discussed this issue with other judges, right?
I would think.
No doubt about it. This was a big deal. And an attorney and a client can waive as much as they want to waive. So she wants to appear into a proceeding and waive as much as you want. But then it stops. It stops. Just because you do something doesn't mean you get to. The Commonwealth says, well, we have it in our possession. Did you hear what he said? He said, we have the phone and we have it in our possession.
We know it's there. Yeah.
We know it's there. That more that the cackle, the kind of like, my ears kind of went up. We know it's there. And so now we want access to it from you, court. Now, is he saying we want access to it from you, court, because we haven't looked at it, or do we think that maybe some
They
police
kind of
officers
already
have
knew.
looked at it? But in any event, she's so worried. Here's my concern. My concern was she was so worried about whether the defense on the ARCA was like pulling the wool over her eyes, but not quite telling the whole story about contacts, right? Here, if you let this attorney-client privilege be breached, and by somebody who is discussing with their attorney, could this have happened? What are the issues? What could be the issues? What if something like this happened? That's not an admission. You're also committing a fraud on the jury there, because it's really not an admission. Brennan saying, "Oh, it's an admission against interest." It is not a penal admission against interest. It's somebody exploring different scenarios with an attorney, and you're misleading the jury then to thinking that it is an admission against penal interest. And so that was my concern, Michael Bryant.
Yeah, and I always thought it was an issue of scope. Even if they did allow any of it in, you're not going to. That doesn't open up the door to everything that attorney-client privilege might protect. So I was surprised she ruled, not as she did, but when she did. I think it's the right rule. It was the right ruling, and it was timely. And now that's off the plate. If you're marking your scorecard, that was gone.
Wasn't your reaction was exactly as mine as the cab is rumbling down?
Yeah, what is the problem now? Why is she cutting Alessi off if he's in stride? He's got his beats, and I guess it was a good interruption.
Yeah, and I'm sure that he must have been. I want to go back. I know that we're cutting it and we're going to replay it. I want to go back and look at attorney Robert Alessi's face, okay?
When she interrupts him?
When she interrupts him, because I am sure that he must have had the same reaction we did. Because remember the other day, and if you haven't seen it, one of our brilliant moderators, Oasis Cat, put it on her ex Twitter page. It's like, you have 2 minutes to argue something really important. And she put it to Eminem, right?
Alessi was trying to do everything he could in 2 minutes. Yeah.
And so that was my concern, that she gave him basically 2 minutes of the most important issue on the, as you said, canonical, as he said, canonical, godlike, on the altar. This is the manna. This is the most important thing, the oldest privilege ever recognized in Massachusetts. And remember, privileges can be taken away that are recognized. Okay, people don't realize that just because they're once done, they could be taken away by legislature, by statute, whatever.
Sure.
Yeah,
sure.
and
Some
when
states have different
talking,
ones that other states don't have too.
That's true. That's true. Yeah, but how was I'd like to go back and see your face, because I think I was listening to it and I was like, wait, what just happened? What happened?
I mean, it was annoyance, and then it was surprise,
And then it was like, hey.
And then I had to go back and look at I said, whose motion is this again? I had to double check exactly what it was. But
no, we're just looking. We're saying about cutting. We're looking for the clip that somebody must have maybe already cut, and we can pull from the internet and give credit, where she cuts Mr. Alessi off. The camera's apparently on his face. And the judge rules that she doesn't need to hear anything more, because she's denying the Commonwealth's motion for the rest of the attorney-client privilege. Also, Michael, they made your point. Mr. Alessi argued your point that you argued last night so eloquently on our show, that had 1,000 people were chatting about it. So obviously it was eloquent, Michael Bryan, that this was old Gretchen, the Voss stuff, right?
Yeah, and that they were just using this timing, to just use that as a springboard for things they could have brought up months and months and months ago. Anyway, she wasn't buying it.
Right. She didn't buy it. She didn't buy it. So, look, everybody has gone against Judge Canoni when they thought that she is being unfair. I think today we should give her lauds. I think we should applaud her that she cut off. She didn't waste the court's time because she wasn't going to have it. She wasn't going to do it. She wasn't going to breach that attorney-client privilege. She thought it was obviously a bullshit argument. And I think for that, we have to congratulate her for doing the right thing and quickly.
And here's how I cut off that congratulatory speech, as Tubi is so eloquently saying now. Yeah, it's unfortunate that it's so rare and so unusual that it makes that kind of impression on us, right? That the right thing was done. I can't believe it. You know.
Well, even as a defense attorney, you know, in court, and we've discussed this a number of times when people ask us, is this normal? As a defense attorney, you always feel like the rulings that should be going for you are going against you, especially in
I
high
think that's true
profile
of-
cases.
I agree. Probably more so defense than the prosecution or a plaintiff in a civil
Right,
case.
right,
But
right.
I think all attorneys in general feel like the rulings are always against them, that they have great arguments that why am I not winning these? You know, that's just part of the representation
Yeah,
mindset.
yeah.
I think you have to be able to believe in your argument. You're not going to win anything.
Yeah, obviously we're having a party here at the entrance to my office here because people are discussing things.
Oh,
And
okay.
so if you're hearing anything over my speakerphone, it's a party to congratulate Judge Beverly Kanani on issuing the right rulings, all right? And I'll be proud to now teach with you at Harvard next year on the
Yay.
trial advocacy
That's
workshop.
Judge Bev won. Okay. So should we, you know, lunchtime things, we usually do some Q&A, but we haven't really planned what we're going to do today. We can talk a little bit about what happened this morning, but it wasn't all that, other than the one thing we just talked about, it wasn't all that momentous, the third-party culpability. Let's talk about that real quick.
Yeah, because I missed it. I missed the
Yeah,
argument on that.
and
so
Diz did a
maybe-
great job of, you know, while I was on, just we ran some of that selectmen council hearing, which I found very interesting. So we ran some of that.
when was that? That was on. The
That was a
selectmen of
week
Canton?
ago, where they
Okay.
talked, you know, blasted Brian Albert for being a councilman or a selectman when he's in the middle of this controversial case. So a couple of citizens just speaking up about their displeasure, even mentioning the cameras outside the pizza joint. I mean, so it got pretty interesting. I think it's a nice way to just get us put the temperature probe into the community and see what those who are willing to speak are saying about what's going on here. So we did a little of that, but during that, this new opposition was filed, and Diz grabbed it quickly, and I saw the note and pulled it up, and we went through it, and then they started the day with that paperwork and with that motion. The motion being the Commonwealth's attempt to exclude any references to third-party culprit or third-party culpability. And so the opposition points out, remember the three people that we've talked about that have now been identified by Yannetti. And he did, I went back and looked, he did identify them in the first trial as well. I didn't remember that.
Yeah, I didn't.
The two Bryans, Higgins and Albert, and then Colin Albert. And so they went through just as we did with the paperwork. It was almost like, Mr. Brennan, did you not hear us on JSTV? We were talking just about all of that. And so we went through all of the elements that the defense has claimed make it critical to bring this third-party culprit analysis and all the law that supports it. What's your take? Are they going to get it? Is the defense going to get this in whole or in part?
Well, here's the problem. I have two takes on it. Okay, the U.S. Supreme Court case on this issue. Let's start with that because it affects my discussion. And the Seminole case, and you don't need the name, okay, says you have to identify a person. There has to be some other dude did it, but there has to be a specific identifier. You can't just say some other dude did it. It's the universe of the world right out there that some other dude could be, right? So here, the reason why the defense has to have specific identifiers is to get it within the fact that the U.S. Supreme Court has said it is a violation of your due process rights if you're not allowed in court as a defense attorney, as a defendant, to identify, to have a defense that somebody else could be equally culpable as the prosecution is making you out to be. All right. So we start with that. Now, where does that equal culpability come from here? I think it comes from the fact that and I think they just barely get it in on this basis. When they first arrived at the scene, if you recall, there's been a bunch of testimony from different people that they believe that Officer John O'Keefe, and he's just John O'Keefe for the purposes of a victim here. He's not an officer. He wasn't killed in the line of duty, right? Was beaten up, if you recall that, right? And our viewers will know exactly where that testimony has and probably pinpoint to it. And as a matter of fact, this morning when I was scanning X, there was somebody who pointed out there is a Massachusetts database dealing with auto accidents that actually references and auto-related deaths that actually references the fact that there is a decedent at 34 Fairview because it gives the longitude, latitude coordinates. And it says, however, it's not related to an auto accident. So I think they barely get it in by the basis of that it looks like that he was beaten up. And that's why the defense has to go with the conspiracy theory about being beaten up to get some other dude did it. But I think they get it in by the skin of their skin teeth.
Okay, and we talked about that mass trans report. That's what I've been calling it. And to be honest, I shot it down in terms of validity and maybe even admissibility, because I think that they're prepared by the most rudimentary level of not even analysis. It's just record keeping. And so that statement that everybody was so excited about, which says deceased not caused by accident, I think is what it says. I'd have to call it up again and look at it. But so what? I mean,
well, that's what the judge would say. That's what the prosecution would say. But I think it's important that the police never went. They're the ones who input into it, the state police or the local police, right? Through accident reports. They didn't do an accident report that could be put into there. And I think the fact their failure to do that may be admissible.
That might be the only way it comes in, because first of all, you're going to have to get the custodian to lay down that foundation for the document itself, how it's prepared, who contributes to it, is it contemporaneous with the events, all of those foundational issues. I could see using it maybe as part of the law enforcement did a crap job argument. I could see that.
Yeah.
But
yeah.
not as a conclusion as to how Officer John O'Keefe died or didn't die. That's the phrase that everybody got so excited about.
I may agree with you on that, the causality, but the fact that no one corrected the causality, I think may be admissible, and it may be good cross-examination material.
That I could see perhaps, yeah. And I noticed on it, to my point that, and Micah, one of our viewers, got mad because I was using a Southern accent when I was doing my filling out my report.
Oh, here he goes again. I leave him alone one morning.
I know,
right?
So I don't have my Boston accent really perfected to the point I can do a lot of sentences. Anyway, my point was that it's just like, this is the kind of report you'd fill out when somebody rear ends somebody on the freeway, right? And so vehicle 1 and vehicle 2, and if perhaps there's a death involved, you'd be making a note on that. And this was not that kind of scenario. I'm just saying those trained to fill out these rudimentary reports don't have the experience or the ability to make the kind of conclusion it suggests in that report.
Right.
I think that's you can attack it on that basis. The other thing I pointed out was it lists the date, right? Listen, the date as 1:28 at 12:36, I think, a.m. So apparently there's something happened 24 hours earlier as well. Then so they even got the date wrong.
So they, but therefore they didn't correct it. Excuse me. Well, I have an allergy attack going on again right now. You all know me. You live with me. You all live with me in my allergies. I was out today, and it's actually a beautiful day in New York City, as you can see behind me. I got my Flonase. I've been starting that. That's one of those that you have to keep using it each day to kind of build up, because it's going to be. I can tell it's going to be bad this year. Yeah. So anyhow, but I missed how they started. I know that is that how they started.
They started with a third-party culpability. Yeah.
And then how did she want? And we're going to probably go through this when we play it. But how did she want it argued? Was it Mr. Yannetti who argued it first, or was it the Commonwealth's motion to seek it out?
No, it was the opposite. Let me get my notes here. It was Hank Brennan. Hank Brennan started.
Did you notice that to me he seemed a little less? What's the word?
That's Hank Brennan.
Less rabid this morning.
Yeah, maybe he's just tired. Yeah,
why not? I mean, geez, you're tired when you have a whole office behind you preparing all this stuff for you, as opposed to the defense team who has to fly in, live away from their homes. Hank Brennan, I'm sure, is living, near his home. It's not a big deal for him. Again, trying to get prepared for jury selection, which starts when?
Yeah, it starts on Tuesday. And it was interesting to hear, we had Scott McGinnis, our man on the street there. He weighed in on what he thought was the process. He said something like 1,000 had been summoned. The judge gave us some more firm numbers today and how it's going to happen. We knew they wouldn't all be coming in at once, obviously. But she said 218 were summoned for Tuesday. And so she's saying 100. Oh, and you missed. I was sharing this from earlier today. Sorry, I digress. See that? There's my my jury summons.
You showed me that last night.
I'm in. So anyway, so she thinks about 100.
Wait a second. He's not in Massachusetts. Okay.
Not Massachusetts. That's the wrong. Yeah.
He
Would
didn't. He
that be
didn't
crazy?
register. He didn't move to Canton so he could get on the jury.
Yeah,
Okay.
that would be some interesting forum shopping. But it's weird. I moved to Connecticut, and I've never ever been summoned anywhere in any place I've ever lived. And I move here, and I get dinged. Which
Oh,
is,
I'm always
it's going to
summoned.
be great. It's going to be great content. I'm going to take everybody along for the ride to the degree that I can. It's going to be fun.
Yeah,
Okay,
no, that'd be
so
great. Great.
the judge says
And you
her-
get put in jail for filming.
for yeah, I have my
Sure.
pen cam. I have my pen cam on.
No,
Because
no, 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 no.
unfortunately,
No, no,
Connecticut is there's two problems with that. First of all,
Yeah.
Connecticut is a two-party state, just like Massachusetts is. That's unfortunate. When I used to do undercover stuff for Extra, we would go to New York or Nevada because there's one-party states and you can just record everything. Anyway, she says she guesstimates 150 to 175 of the 218 will actually respond. Remember, I was asking that question under the ASAP Rocky when there was a big uproar about racial mix. And I said, we never learned how many just didn't show up, right? Now we're getting a sense from this judge, and she's acknowledging people don't show up.
Yeah,
right?
but ASAP Rocky was a different story. All of us have ever
Well,
tried
yeah, but I'm
case
talking
in
about just the-
downtown LA know
Of
that
course.
you generally have a bigger jury pool than
But my
zero.
point is, what if 50 people didn't show up, and what if 40 of those 50 were African American?
Then you
That-
then to be something wrong in Denmark, to quote Shakespeare. Okay.
Something
I
rotten
think.
in Denmark.
Something
So,
wrong in
so,
Denmark.
but I think
I'm making it modern.
my point was, some people blow these things off, and if you don't know the mix of those who blew it off, you can't make a big racial discrimination claim just yet. ASAP Rocky made that claim, not an issue here. So she's saying, do the math here, roughly 75%. It looks like is her guesstimate. 75% of the people summoned will be there, and so they're gonna fill out the questionnaires. She's saying, that could take an hour or 2 hours. Then she's gonna tell the last 50. I don't know how that's going to be determined. If it's the numerical 50, she's going to have them go home. Okay. Then the rest will stay, and they'll begin the sorting out process individually at that point. She also says that when they go to if they can get together, both sides on a for cause challenges based only on the questionnaire first, then that's the way they're going to do it. They're going to have certain names that they propose for cause. If both sides agree, they're just going to be out. There's going to be arguing. It's just going to happen.
Right.
So she's trying to streamline this as best she can.
Yeah, that's usually the way it does work. If you can talk to the other side, there'll be
Sure.
people that you both agree on are not appropriate and shouldn't serve and can't serve because you could just tell from the questionnaire that they're going to get removed anyhow, only because of the fact that maybe they are self-employed and they won't be able to stay or whatever, and you can agree upon it, or they have a conflict.
Right. Yeah, and then obviously that'll be fleshed out if there's a problem where one side says cause, the other says no, we're good. Then you have to work it out, and Judge Bev will figure out ultimately who does and doesn't. And we haven't heard peremptory challenges. Haven't heard that number yet.
Right. Do you remember in the first trial whether she granted a greater number of peremptories? She may here because now of the publicity. Somebody has to apply for it. Someone has to apply for an increased peremptory, especially if I don't know whether she's going to increase the amount of alternates. And if you increase the alternates, a lot of times you may increase the amount of peremptory challenges.
Yep.
California is interesting because in your state, in California, you get a separate designation of the amount for peremptory challenges for alternates, and so if you increase the standard number that you have to make a motion to increase those also,
Which is pretty pro forma. They'll let it happen, and then the length of the trial obviously determines how many alternates, and then that affects the peremptory. So we don't know number of alts either yet.
So you asked me my feeling about some other dude did it third-party culpability.
Yeah.
What was your feeling as you were listening to it? And again, we'll probably replay it and comment on it this afternoon. I'll probably stay and redo the comments on it.
Yeah.
What was your feeling?
I felt all along that they have a right to raise the issue, but I think by refining it to those three individuals and then having a basis that is either theoretical or has been proven by prior witness testimony for some sort of altercation potentially happening, the flirtatiousness between Brian Higgins and Karen Reed that didn't come to fruition, and maybe that led to some animosity between Brian Higgins and Officer John O'Keefe, and Brian Albert having his history, and we'll talk about this too, his history of physical violence with other officers, which they say they're going to call from the defense side, which is obviously a bad character testimony. We'll have to get into whether that's likely or not. But I think they've created at least the foundation for the possibility that these folks were involved in an altercation with Officer John O'Keefe that night.
What about Chloe?
Poor Chloe.
Well,
Chloe's
I
been
always
mixed.
say that.
Chloe's been in the
say,
mix.
yeah,
And, you know,
I say
there-
that. What if you have? Let me go. Your Honor, this is Mr. Lewin speaking here from ASAP Rocky. I'm
But
bringing
Your
back the
Honor.
ghost. But Your Honor, I have a hypothetical question to you, and I want you to answer my question, not what you want to answer, right? But Your Honor, what if hypothetically John O'Keefe enters the house, Chloe somehow attacks him. Chloe ends up being the person who actually is the killer animal, you know, blaming the German Shepherd, of course, right? And it's not really the people that did anything. You're on.
I'm sorry. Every time he hears his name, he pops up. I just don't understand it. Mr. Lewin, I mean,
So is that a Saudi defense, or is that a cover up to the dog did it? You know, in other words, does a prosecutor even dabble with that?
that's interesting. They've certainly tried to make it part of the mix. The defense has. They've talked about poor Chloe's, history of bites 2 times that we're aware of, and and the statement by either Brian Albert or one of the Alberts that Chloe doesn't like strangers. So that's all in the mix. We know why.
Character evidence.
Character against the dog. Yeah, and most of these municipalities, the one bite rule is in effect. If you have a dog that's bitten one person, you're screwed, because anything that happens after that, it's strict liability. So I think they've laid the foundation for it, including the dog bite connection. The question is, will Bev believe they've done enough?
Interesting. So, okay. So before we go back to what you watch with the Saudi, as some other dude did it, or some other dudes did it, or there was a concert of some other dudes in a cover up that did it. Let me bring you back to this question. Okay. All right. So you have Proctor. How does Proctor, the Proctor factor, Michael Proctor, the state trooper who was the lead investigator, now has been fired. How does that factor, the Proctor factor into the some other dude did it defense?
Wow. I think that's going to be part of their Bowen defense, that whole inefficiency of the investigation angle. Because if you argue that Proctor blew the investigation, he was the lead investigator, of course, and he didn't do the things he could have done to point to the culprit, third-party culprit, then that it kind of helps them, they would say prosecution would say bootstrap, but it will help them bring that law enforcement inefficiency into the case to support that some other dude did it, but we don't know about it because the law enforcement didn't do their job. If they had, we would have far more information about the other dude or the other culprit, and all we have is what we've got now, which is these 3 folks we think acted in concert. There was a motive for that to happen. The dog may have played a part. We'd know so much more if Proctor had done his job.
Okay, so now let me ask you the next question, hypothetically, counselor. All right, so now you've listened to pretty much all the arguments, right? All the pretrial arguments are pretty much done for the most part, I think. You never know with this case. All right, you and I have discussed in the past that we think that the prosecution should dismiss, delete, goodbye to count 1, the murder count, the intentional homicide count, go with the manslaughter counts, whether you want to call it aggravated manslaughter, negligent, whatever you want to, however you want to phrase it, on the basis that perhaps Karen Reed accidentally touched John O'Keefe. Maybe she backed up and he jumped out of the way, or she didn't see him going into the house really, and therefore she knew that he was not able to take care of himself. He was so drunk, and since maybe he fell in the snow, cracked his skull, and therefore she's liable. Any of that. Do you then, as a prosecutor, if you're Hank Brennan, do you decide to drop that murder and then pick A, B, or C as the specification to the charge dealing with manslaughter at this point?
Well, I can't get past that initial hypothetical, dropping that second-degree murder charge. I don't think it enters any of the folks on the prosecution side or the Commonwealth side as a whole. I don't think Mike Morrissey would ever allow that to happen. It makes no sense, of course, because we've argued about it so many times. We know that it is a tough nut and it's overcharging, and maybe it was done originally to help leverage some sort of plea deal. But now they're going down with the ship. I've seen nothing suggesting that they would ever do that. So I can't get past that.
But don't you think they would don't you think they'd put the defense on their heels? I mean, you and I have a reputation on this channel to try to be fair on both sides, right? Bring both sides to the argument to everybody. Both sides, if both sides hate us, that means we've done our job. Wouldn't it put the defense on their heels then to say, we're dropping the murder charge? This was an accident in some way. We can't tell you exactly how it happened, but it was an accident, but it was manslaughter. It was a pretty egregious accident in some way, either in A, B, or C. Don't you think that would put the defense's conspiracy theory that there was a beating in the house on their heels?
No, I think it still applies. It still applies because remember, their defense is that no matter what happened, it wasn't Karen Reed. Whether it was an intentional second degree, I'm running this guy over because I'm tired of him, he's cheating on me, or whether it's something that happened because I was a little too tipsy and he was in the wrong place at the wrong time and I just somehow I bumped into him or he was leaning against the car when I drove off. All of those things involve Karen Reed's actions. And their defense is that what she did had nothing to do with his death. It all happened inside that home. And that doesn't change, even if the top charge disappears. I think the prosecution's position is better. I don't think the defense changed, but I think the prosecution's position is much better without that top charge.
Yeah. Yeah, interesting. Now, I think in our drive, we have loaded the clip that has, and I'll talk about it, that has given us the most, like, what happened there? That's when Judge Beverly Cannoni denied Hank Brennan's motion to breach the attorney-client privilege and all. And if we do have it,
I'm getting it. I don't know what it is, but we're going to have it. We're going to just throw it out here in the blind.
Thank
see
you.
What happens.
Thank you to Oasis Cat, who actually got it for us to put it into the drive, and our producers who are doing this on the fly here. And then at some point, we should talk about the Vanity Fair story that came out apparently today. But maybe we'll give our viewers
They had a new one today. I did not know that.
Well, true crime. I'm getting it here, hot off the presses from unless it's been republished today, right?
Okay, let's go to this video. Shall we see what happens? Should we go to this?
Yep. Yeah. Okay, let's watch because I haven't seen it.
Okay, here we go.
The case the Commonwealth cites supports the protection of the attorney-client privilege. With that law jurisprudential predicate in mind, I now turn to the statements at issue here and their import to that analysis.
You know what, Mr. Leslie, I'm going to stop you. I understand the Commonwealth's argument regarding waiver. I understand that the request is now obtained, but I'm not going to give you this information, Mr. Brennan. I don't even think it's appropriate for me to have so the motions tonight.
I didn't understand what she said. I was a pin drop, and I want to get a freeze frame. I want to take a screenshot when we're off the air so we can use it later on when we do our program tonight of Alessi's face, because he was like.
Well, and in the background, right over his shoulder, is Aidan Carney. So when we talk to him tomorrow night at 8 o'clock, we can get his reaction to having been sitting there watching this unfold, because you can see him react when the interruption takes place.
Let's do it again. Let's run it again, because also I couldn't hear exactly what she said.
Yeah,
I think that's
I'll
why.
give you, because I've heard it twice and now I kind of heard it.
Yeah.
She talks about she understands the Commonwealth's argument about waiver. And then she ultimately says, I'm just not going to go there. I'm going to deny. Okay, so now I have to find it again. I'm sorry. Hold on.
That's okay. That's okay. And I think maybe tonight when we do our show at 6, we'll and have our questions with everybody.
You see Aidan right there.
The protection of the attorney-client privilege. With that law jurisprudential predicate in mind, I now turn to the statements at issue here and their import to that analysis.
You know what, Mr. Leslie, I'm going to stop you. I understand the Commonwealth's argument regarding waiver. I understand that the request is narrowly tailored. I'm not going to give you this information, Mr. Brennan. I don't even think it's appropriate for me to ask, so your motion is denied.
Okay, so
I did do a
and you could
screenshot.
see.
I
You
won't
see
post it
Aiden.
after. Yes,
You
I
see
did do a
Aiden in the
screenshot.
background.
Yeah.
Yeah.
I did the screenshot. She's not going to take, but that's why I think when I was in the taxi listening, I didn't hear what she had done. I just know that she had stopped him, and I figured, the universe is just falling in on itself, and all attorneys in the United States are now like, why did you do the damn documentary?
Yeah, really. So the audio has been lower, it seems to me, today.
Yes, I agree with you.
From
I agree
all
with you.
sources, but especially she's always so breathy. You know, she's kind of breathy, and so it's when the volume is lowered, she's much harder to understand.
Yeah. No, I agree with you there. But that's a moment that we could run and rerun and rerun, and I'm sure that everyone's going to rerun that for Bob Alessi because his face was just so right.
Yeah. Because I mean, we didn't stay on it. It wasn't on him long enough to see her transition from "I'm stopping you" to "It's a good reason I'm stopping you, and you've won." Because I'm sure we would have seen something change in his face when he realized that she's just not jerking him around on his argument, right? That it really was over.
Yeah.
Miss
By
Shorty.
Lisa Shorty, member for 1 month, 2 months, sweet Justice Serve TV. She's how many now with daylight saving time here? She's how many hours? And now I've lost. Is it 17 hours ahead?
I think it's because they don't do daylight saving time there, do they?
She said no. I think the last time we were.
Yeah. So does that make it now 15? I don't know. I could cheat and look that up. I was just getting used to whatever it was before.
So Bob Alessi, and you know what the thing is too. Yesterday, and we didn't get a chance to talk about it. I think at one point, she said to him, the judge said to Bob Alessi, and you have to understand where this comes from. And let me again go back. When you teach how to try a case to young lawyers, you tell them with the jury, you're going to tell the jury you run your thing. You have to tell the jury what you're going to tell them. You then have to tell the jury what you're telling them. And then you have to tell the jury what you told them. And that's we batter that into people's brains. So when Bob Alessi first came up, I think that's what she said. Are you going to tell me what you're telling me, what you told, what you're going to tell me, what telling me, and then what you told me? And he said, no, I'm not going to do that today, Your Honor, because that's the way he argues. He argues the way you would argue to a jury. Your Honor, here's what I'm going to tell you. Now I'm telling you.
Mr. Alessi, could you just get to your argument, please? I know I have your papers. Yeah. So, and I'm okay with that too. If you can do it quickly and move on, great. But he's very deliberate, and he's got his points to make, and it sometimes takes a while to jump in.
Yeah, they do have daylight saving time, Miss Shorty in Australia, and it's 17 hours earlier. Thank you very much.
17 now. I think it's 17 hours.
Yeah.
Later, isn't it? Later. Yeah, it's later.
I think they're in front of us, right? They're ahead of us, right?
Yeah, it's what is
we're
today?
17 hours behind.
What is today?
It's
Tuesday. So it's Wednesday morning there, like 4:30 in the morning or something.
Yeah. Hi, Miss Shorty. There you are. There she is. There she is. Okay, confirm to us, Lisa, what time it is in your neck of the woods, as Al Roker, a weather person. It's 4:38 a.m.
There you go.
Later. Okay, 4:38 a.m.
On Wednesday.
Okay.
On Wednesday morning.
Yeah.
So I think I can't think of anything else from this morning that happened that.
But what was the argument from Hank Brennan, because he's doing
on the original motion, the motion for the third party culprit?
Right. What was his argument?
Well, basically, as stated fact, Officer John O'Keefe never went in the house. So let's just get past that. I mean, that was his deal. There's no evidence he went in the house. Moving on. He talked about the kiss that the defense brings up, in which Karen Reed at some point kissed Brian Higgins, and then we know that It really never went beyond that. And the defense is saying that is motive to instigate something happening in the home attacking Officer John O'Keefe. And he's saying there's no evidence of that. There's just no evidence. It's beyond the pale. He used that phrase. It's beyond the pale. He also poo-pooed the defense, suggesting that John O'Keefe had been ordered to the home. Remember, there was some text back and forth. First, the address was given because they didn't know the address at 34 Fairview. Then there was a follow-up text at some point. Are you coming? Are you still coming? He wasn't willing to consider that an order to be there. So the defense is arguing it from their perspective. Obviously, the Commonwealth is denying that that's what it really meant. We don't know. We don't know.
We don't know. Yeah, so that's what he said. That was it.
Well, I'm looking at some of the other. Those were the key that he kept pounding on. Was there's no evidence that John O'Keefe went in that home. No evidence. He's really hanging his proverbial hat on that.
What and there's been a lot of discussion about these things, these spies that we wear on our, on our wrist, your Apple Watch, right? Which then goes into
info.
your health data, and it goes into all sorts of stuff on your phone that suggests that that John O'Keefe walked up 3 flights of stairs. How is it, and our viewers can tell us more, that it can tell that there was a vertical going up steps as opposed to just a movement, and doesn't matter.
Well, yeah, and I think the location data says that he was up and or down 3 flights of stairs, because otherwise it makes not a lot of sense. He had to have descended to the basement, then went back up to the first floor, and then descended again to the basement. Because to go up 3 floors, I think you're past the roof.
I think that's right too. That's why I'm asking you the question, because if I'm in the jury room and I'm saying, wait, I'm a little confused about this other juror, could you explain it to me?
Yeah, that's my understanding, is that the motion was ascending and descending 3 floors, some combination of. And I know somebody's talked about, we talked about this before. They said, well, that had to do with when the car was making a wide turn. And I've been on that street. It's pretty damn flat.
Yeah, it's pretty.
And it's
right.
also,
right.
You'd have to travel quite a distance unless you were making a wide turn on an upslope where you go up, then you come down. And you go, that would give you that, what is it, 15 feet, maybe 12, 15 feet elevation change. A normal house is 8-foot plate line. That means from the floor to the ceiling is 8 feet. Add a foot to that for the difference between where the joists hit the stairs. So it's 10 feet max. So you'd have to have a hill of some sort.
So
10 feet up, 10
whining,
feet down.
give it that whining baby crying thing again, that little one crying thing again. So if indeed the Apple Watches don't say you're going up and down stairs, it says steps, but then it registers a height elevation. Is it the coordination of the steps with the height elevation on the Apple Watch that the defense is using through their experts?
Yeah, I don't think it was as clear as it needed to be. Maybe it will be this time. But yeah, that's the correlation. Most a normal flight of stairs is 13 or 14 steps, because steps are usually 8 or 9 inch rise. And who knows that? I only know that from having built stairs. I don't know if that's going to be part of the testimony or not. But that would be the equation, right? You're going up 13 or 14, 9 or 10 inch, 8 or 9 inch steps. That would account for the elevation, but it definitely relates to steps as well.
It relates to the steps and the elevation. But interesting, because I don't think they made that as clear as they should. But the Commonwealth didn't dispute that. They were just saying, well, it couldn't have been. It was this. It was that. I think that's going to be fleshed out. It's going to be fleshed out by the defense and fleshed out by the prosecution. Both would like to have their way around that, their way of dealing with that.
I can't wait to hear that explanation. To explain
we
that
should
away.
do that. We should do that. Fleshed, when one side is proponent is the proponent of something, we should say they're fleshing it out, and one side wants to put it in the toilet, we should say they're flushing it out. Right?
And flushing, I got it.
Flushing and flushing.
I got you. All right.
Yeah.
Steph McGarry 2. Thank you. Becoming a YouTube member. Appreciate that.
Yeah.
So
that was it. But he was pretty. Even when I got on to listen, I just thought he was pretty. Even his argument about the, in their papers, they were like, yeah, she waived the attorney-client privilege. We get to that. Yeah. But I don't think from what I heard in the cab that he was so gung ho on that this morning. Maybe he
Yeah,
got a
he
feeling from them, from Judge Beverly Canoni in advance that wasn't going to fly.
could be, and it is interesting that she let him go through the entire argument. She never cut him off, never interrupted him, never gave him a clue that don't waste your breath.
But that to me is bothersome in this regard, because he goes through that argument, arguing therefore that these are admissions against interest, admissions against penal interest. I think he even said that at one point, right? And so therefore, again, we create that ambience for sort of in the public out there that she's made some admissions when they aren't. And matter of fact, even in the first trial, they were talking about her wondering whether could I have done it? Could I have done it? What happened here? And then she cuts Alessi off when he's going to say, there's nothing there, and rightly so, right? But you don't have that ambience now that from the defense that equals what the prosecution got.
Right. Yeah. I don't know why. It's almost like she was sandbagging the prosecution by letting them just lay out your argument. I'm listening intently. I'm ready to, openly decide how this should be ruled on. But clearly she'd already decided. Clearly.
Yeah. Oh, no doubt about it. No doubt
So,
about
there
it.
was another thing that came up that we haven't talked about.
Okay.
Of course, there was some things taken under advisement.
Yeah, she
Third-party
said she's gonna
culpability was
have
taken under advisement. The Commonwealth's motion for production of records that went to Unsolved Productions.
Oh, that's
for
right.
The ID show. So this is interesting. Apparently, there was some contact between the Commonwealth and Unsolved Productions, because the Commonwealth said that there are roughly 200 plus hours of unedited raw interviews. Okay.
Wow.
That it went into this 4.5-hour show.
So that had to come from the producer to the
Yes.
Commonwealth, right? That
Yes.
information. Right?
And that's exactly what they think happened. When Alan Jackson was asked about that, because really, do they have a position on that? They can't really step into the shoes of Unsolved Production. They've got to fight their own battles. Alan Jackson and the defense have to deal with the fallout, but they can't really step in and say, hey, we're objecting to their production because it's not the defense production. And so there has been no appearance officially by Unsolved Productions. But again, obviously, they have an agent for service of process. So they've submitted to the jurisdiction of the court, at least for purposes of these documents. And there's been a conversation. That's all we know. And that's all Alan Jackson says. We haven't talked to Unsolved Productions. Sounds like the Commonwealth has. So that is still up in the air as to what's going to come, if anything, and how it's going to affect scheduling. I mean, Mr. Brennan did submit to the court that it's 200 plus hours, but we're not going to ask for a continuance to review this material. We'll get it done during the course of the trial. So, I don't know. He thinks he's going to get it.
It'd be interesting to see, because if Unsolved Productions has submitted to the jurisdictions, has had these discussions, they may want to submit papers. And I think Alan Jackson, he took no position on that because that wasn't his dog in the fight, right?
Yep. Yeah.
Took no position on that. Now, the Judge Beverly Canoni, I did get that she said at the end when I was wiring myself up here to get on with you, that she was going to have a decision on the motion to dismiss at the end of the day.
Yeah, but I almost forgot about it,
Well, could she dismiss the murder count?
Oh, man. She could. Of course, she could. She said she's also going to have a decision on the buffer zone. Those are two issues on opposite ends of the spectrum in terms of importance.
Yeah, and there was something else that I heard, and Mr. Leslie got up there and said something, and I missed it again. But for those who didn't get the whole thing, it said Mr. Brennan doesn't have to be so dramatic because he mentioned something about grave concern again.
Hyperbole.
What happened? Hyperbole.
Well,
what was that about?
It was very unclear to me. It's one of the production issues that has not been resolved. And along the way, there have been times where the judge has asked and the parties have agreed, yeah, we're going to work that out. We're going to work that out between us to fine tune some of the production. I don't know which one this was. It was not very clearly identified. At least I didn't get it. But Brendan was making the point that, yeah, we still haven't got it. We're supposed to talk to them. We haven't gotten anything. And Leslie was just saying, look, don't overplay your hand. Don't have the grave concerns. will talk. So they represented to the court. They're going to talk about whatever that production issue was. I don't know what it is.
Okay, and then that was okay. And then there was also something, and we have a question on the screen. To making account is always with us. Thank you for being a member, right? That's a member. And my eyes are like, hay fevered out this morning. I'm behind, but why is having an earpiece microphone not a reasonable accommodation? As always, the reason we've always done it this way should not be an appropriate response. Let's go back on that. I think that every defendant should have the ability to hear what's at sidebar, even when there's objections. They shouldn't be sitting back there. That's, as we know, sidebars can be some of the most important parts of a trial. And this is because what Alan Jackson says, look, jurors are kind of uncomfortable with having a person accused of murder standing next to them up at the bench. I don't know if she dismissed that out of can. We haven't done it that way, but I think I heard her say that she has an absolute right to hear what's going on.
Yeah, she said she can come up here every time if she wants. That was the answer. And I can't promise this accommodation because he even offered, well, how about if we have a wireless mic that's set up? And
they're worried about somebody. They're worried about somebody hearing it. That's what they're worried about.
Sure, yeah, somebody could hack that. I mean,
but you know what? I'm not sure if I'm Alan Jackson. Yeah, you could protest a little bit, but you know what? If you have Karen Reed up there with the jurors, Michael, let's think about this as lawyers. Then they're used to her. They're not afraid of her.
It's not like Charles Manson is standing there, with a swastika carved in his forehead. I think it's more a practical matter because, it looks like a big parade that goes up there. But how many cases have we seen where the defendant is always up there at bar? Always.
Yeah, and I think it helps because she's standing right next to people going to decide her fate. And, it's just like long trials in order to the benefit of a defendant, right? Why is that? Because the jurors see them every day. They see them interacting every day. If they go 3 months, 6 months, they tend to help a defendant because they get to know them in a different way. I think it may help.
I don't know that it strikes me strongly either way, but I think if the defendant is up there, it looks like, well, she's invested in this. She cares. She wants to know what's going on because it's her life on the line. So I don't see it as a negative. I don't know if it's a big whoop-de-doo positive, but I don't see it really as a big negative. And the court, the way it's set up, if we're looking at the bench, right, the jury is over here. That would be, when we're seeing it on camera, we are the jury. That's the perspective of the jury. So when they have their sidebars, it's on the opposite side of where
the jury is.
The jury is still pretty small. It's a tight space. But they'd see her walk. They'd see her get over there. They see her involved. I don't think there's a downside to doing it other than just the mechanics of another body up there.
Well, yeah, that's about it. But the mechanic. Well, but I'm thinking about it. They all go up there, right? They're all going to bring their computers. They don't seem to have a jury consultant that's in the courtroom, right? If they do have one, the person is not in the courtroom, so that you don't have that person because there's always a fight about whether that person could attend sidebars in cases, so they can help the defense, depending on what the judge says. So I don't know. I'm not sure. But what did they do during COVID? Because during COVID, remember, people weren't going up to benches. Everyone was having earpieces on, right?
Yeah, as best I can recall. Yeah, and they had the white noise machines, and they had kind of walkie-talkie type two-way communication.
Yeah,
but hey, it's not the way. It is not the way.
Yeah, but I think they're more concerned about somebody intercepting wireless communication.
That's what I think for wireless. Yes, I think there's no doubt about that. It wouldn't take much hacking to do that.
Look, we see what people can do on X Twitter, right? In terms of understanding what's going on and dissecting experts' reports and experts' testimony. I can't imagine what people can do. I mean, you can't really put a Faraday bag over the heads of everybody up there on top. Yeah. Oh my goodness gracious. So the grave concern issue was mentioned. The motion to dismiss at the end of the day. Hey, it'll be interesting to see if she dismisses anything. Certainly, it'd be really interesting if she dismissed the first count, the murder count, because then that whole double jeopardy issue is meaningless, right?
It is as to the first count. Yeah,
as the first count becomes meaningless.
Janae has a question for us. Do you think it's possible they pick the jury and then have an evidentiary hearing prior to trial. Looking forward to going through the motion to dismiss. Evidentiary
Maybe.
hearing on what?
On the
I
ARCA
guess.
people, because she said the ARCA people have to, before they testify,
They
still
do want
have
to
to
voir
go
dire them
through
again.
the voir dire them again. So yeah, that could absolutely happen. It could absolutely happen. That's why everyone's agreed not to mention the issue of and that's been an agreement, not the issue of the monetary payments in the opening statements.
Right.
Right. So yeah.
Yeah. That's going to be an ongoing issue, I do believe, especially with the ACA people.
Yeah.
Maybe with some others too.
And then also the unsolved productions in terms of, what if they interviewed somebody who's a witness? Does that mean if what they say in tapes that aren't under oath, there has to be hearings on that, right? There has to be hearings on that.
On which part? I'm sorry, I was looking at comments.
Unsolved productions. Let's say that 200.
Oh.
And there's
the
witnesses,
200 hours.
right? There's witnesses. Certainly what attorneys say is not coming in. That wasn't used on the cutting room floor. But what if there's other stuff that hit the cutting room floor, not being from Karen Reed?
Yeah, I don't know. Well, based on you mean from third parties that are
parties that are witnesses? Maybe they're witnesses, right?
For what purpose? For the truth of the matter stated? For
the impeachment, right? Yeah,
impeachment, maybe. Inconsistent statements. If it's a hearsay issue, you might be able to get it in as an inconsistent statement, depending on who says it and what the other statement might have been. Refresh recollection. You might be able to get something in on that if somebody doesn't remember saying something, but here's video of them saying it, right?
Yeah. Yeah. Now, Janae also says, okay, clarify this. I meant on evidentiary hearing on the Sallyport video and jury tampering claims if she denies motion to dismiss.
Okay.
Okay, Michael.
I don't see that. I don't see us if the motion to dismiss is denied, basically where we are now. I don't see them doing that. Not on those issues, unless they're related to ACA again.
Yeah,
depending on how much they relied on that video, if at all.
Well, also remember the defense still has, they have the dog bite reconsideration for a hearing, for a Lanigan hearing? Isn't that still up there, or did I miss that?
I can't remember. Has that been ruled on?
Yeah, she didn't mention it this morning, so.
Yeah, I don't know. I can't keep up with all these. I'm sorry. I have to admit, I can't keep up with all of them. And they don't mention on the docket. They won't put orders on there if it's just a quick oral decision.
Yep. Yeah, it's still pending. Erica says it's still pending. That's what I thought. Yeah.
And so, and Judge Bev likes to just do handwritten notes, on the bottom of stuff, sometimes.
Well, that happens a lot.
I know, but it makes it less easy to track.
Right. You're absolutely right.
Not posted and stuff.
Yeah, you're absolutely right. That's because, when you file things, and maybe it's changed, but when you file things even a couple years ago, you actually file them with the clerk in that court. You don't go to central filing like,
right.
when you file in federal court, right? Oh my gosh, you better make sure you go to the federal court clerk and everything gets uploaded, all your exhibits and everything. But in Massachusetts, you usually bring the original papers to the court clerk in that court because they have that roving system of judges, right? And assignments and all. It's not quite as it is in many other states. So, so it's a little bit different. Michael, you've been on the other side of this. I'm really interested in this unsolved production. Now, they had conversations with Hank Brennan. They apparently must have told him they have 200 hours.
Yeah, unless he just pulled that out of his butt. Yeah, that's what we're assuming.
Why would Unsolved Productions agree to give up anything instead of fighting for journalistic privilege in terms of things that are on the cutting room floor? Talk to me about it from your side when you do these documentaries.
Well, you're gonna first of all, you're just gonna be arguing that it's your work product, you own it, and unless somebody can show you a reason that you should cough it up, there's got to be some sort of in-camera review of 200 hours of video. That's the first thing.
Oh,
yeah, I mean that's not going to happen.
Right.
But in theory, that's the way it would have to happen, and then the judge would have to decide whether or not it is A, relevant, and then B, admissible, regardless of the relevancy. So it's a few steps you'd have to go through, but Unsolved Productions has to raise that objection. If they want to just say, here's my 200 hours, knock yourself out, they can certainly do that.
Yeah. Erica said they received a defense expert report on the dog from Garrett Wing yesterday. He'll only be called to counter Crosby. So going to be interesting. It's going to be an interesting chess match, shall we say, right? About whether or not the Commonwealth is putting to the test that they have Mr. Crosby. They have him in right now. Do they really want to call this guy? I mean, really? You know, you have the dog. Just put the pictures of there with the dog, the Chloe, who sent people to the hospital. You know, bingo, bingo, bingo. You know.
I was surprised there wasn't more objection from the defense about the testing, the molding that they weren't present for.
Right.
You know, that I don't think there was ever any notice of that they could have participated in. Because usually any kind of test, maybe they just figured it was so outrageous and so unlikely to be admitted that they didn't want to bring it up. But I would have thought they would. That was the first thing I thought was the defense there when they did this? Because remember, it came up during the Lanigan hearing with Dr. Russell.
Right.
And
Now,
that's the first time we heard about it. And I
right.
was like,
We
really?
heard.
Did the defense go and take part in that?
Yeah.
So
Yeah, that's really. Oh, by the way, according to Glamasu, okay, LA says according to Glamasus, they sent the summons to the wrong unsolved mystery.
well, Unsolved Mysteries is actually a show, and this production company is called Unsolved Productions because the woman, Maurer, I think her name is Terry Maurer. I may be getting that wrong.
I think you're right.
She did a lot of work on that as a producer, and then she started her own company, took the unsolved part of her prior work experience and made it her production company name. That's my understanding anyway. So if they just send it to Unsolved Mysteries, it might be a problem. And I don't know how many unsolved production companies there might be out there.
Yeah, I don't know. By the way, you know, you guys can't see it, but we have we see our backstage, and our producer has put backstage Justice Served, and it has both of our avatars combined. So Michael, you're right next to Tubi the poodle, right? And his little, it's the cutest little thing I've ever seen.
Well, people couldn't tell at first what Tubi was doing or what your avatar was. But
yeah,
I'm
gonna have to get either Tubi bigger or put my avatar in there. But we were trying to test him out last week, if you recall. And so I said, okay, I can put Tubi the poodle in. You know, anyone who follows my Instagram, which is @KennyBodden, which is my personal Instagram, even though I post that we're going to be doing these shows, knows Tubi the poodle. He's known by everybody around here. He is, you know, he wears a little bow tie, and he's not like a poodle with his ears, big ears. He's got his ears shaven flat and all. And they all know Tubi the poodle is my adorable little guy who I absolutely
little
just like.
guy. He's a strapping
pounds.
doggy.
Yeah,
really?
like,
only 50 pounds?
He's only 50
Really?
pounds. Yeah,
'Cause
just
he keeps
like
so tall.
you have the cutest little.
And Domino's about 50 pounds, but it's a different package. You know?
Wow, Domino looks to me so much bigger than Tubi when I see him. I guess it is a different package. Tubi's all hair.
Yes.
Tubi's got 30 pounds of hair, poodle hair up here. Anyhow, yeah. And it's, by the way, Prince Lover, it's to be, as you know, we would actually, to be or not to be is where it came from in Shakespeare. All right. So we call him two with the B. So just so you know, tell Tubi hello from our Shih Tzus. Yes, absolutely. Someday all should put your avatars in, put all of your dogs in,
Party.
Dog party and Tubi the poodle. You know, and dogs play such a great role in so many cases, as in this case. There's Chloe, and we have dogs that find bodies that have been missing, and we have dogs that are so involved in crime, and we have canine dogs at the airports, canine dog. So dogs are such an important part of not just our lives, but of crime solving and the crime community life, and also just all of you who have dogs, cats. Our fur child, Missy Mayhem, has a parrot that you've seen pictures. We put her on, Pixie, the parrot, and all. Yes, let's have a party for all of our pups, whether they be canine.
We did have. Remember, we had the our pet-a-thon. That sounds weird.
Yes,
for the fires out.
Yes,
in
we
LA.
did.
Yeah.
We did. We actually can go back and look, and we ran a lot of people on to try to raise money. They're not going through us, but suggesting some organizations for the fires that they can donate to help animals, and we had a lot of people that donated the time to come on the air here. So we are, both Michael Bryant and I are truly into loving our pet children. So Wendy, my parrot whistles the Pink Panther theme.
I like to hear that.
Miss Shorty says we don't deserve dogs. Yeah, I know. All right, so that's what I had going. Should we replay the moment that Judge Bev may end up being the person of the week for her ruling on this next week?
Are we talking about the same
Same one.
moment?
Let's replay this moment.
You're loving this moment, I'll tell
I
you.
love this moment.
Okay, here we go.
The case the Commonwealth cites supports the protection of the attorney-client privilege. With that law jurisprudential predicate in mind, I now turn to the statements at issue here and their import to that analysis.
You know what, Mr. Leslie, I'm going to stop you.
He's frozen.
I actually taken the screenshot of that.
He's frozen. Here, I'll back it up for you. Hold on.
And I will send it to put in our assets.
Whoops.
You know what, Mr. Leslie, I'm going.
There it is.
There it is. That's the
Then
screenshot.
you can see Aiden is shifting his gaze from Alessi to the judge. Like, what the?
Yeah, but Aiden's looking like, well, I know what's going to happen, right? We're all looking
I
like that.
understand Carmel's argument regarding waiver. I understand that the request is narrowly tailored. I'm not going to give.
I'm not going to allow that. I'm not.
Yeah,
So-
but that's, hey, look, let's give her credit. That's the
we
right
did.
ruling. We're absolutely giving her credit. I'm giving her. I'm actually putting a vote for her to be person of the week because of that.
Oh my
because of this ruling
gosh.
for
Well,
next
luckily it's only Tuesday.
Well, you know what? We
Let's see
try
what
to be
happens.
fair. Look, people attack us. We're not. We say we give them both sides. We call them as we see it. This is how I see it. I think this is the most consequential ruling for lawyers around the United States that was made today in this case. Maybe not as consequential for Karen Reed, but consequential for the jurisprudence system. And for that, I'm giving her credit.
All right. Yeah. It'll definitely have, it would have had shockwaves across the country had it ruled the other way. No doubt about that.
Yep. Okay, so yes, credit for credit is due. Now, we have a couple of things we can do. We can rerun this morning, I guess, and I would stay. I don't know whether we can rerun it because your avatar is there, and I could stay to answer more questions, or we could close up, rerun it as was run this morning, and then we get back on at 6 o'clock and discuss everything that went on today, and we'll see if we can get a guest on with us tonight. Now, you know that tomorrow night, just so you know, at 8 p.m., Aiden's going to be on, Aiden Carton's going to be on, Dr. Turtleboy is going to be on with us live here. On Friday, we're going to have Doug Weinstein on at 5 o'clock live because he weighed in on this whole privilege issue and the whole documentary
It
issue.
got him off. I say it got him off the couch. He's got a lot of things he's working on. People don't just, not everybody's able to just focus in on this Karen Reed case and follow
Yeah.
the blow.
Yeah,
But
that's right.
nothing happened.
And then we're
Nothing
going to be
happened.
on.
They got him off the couch.
And then at 6 o'clock, we're going to go to Will DeGlara, right, on Friday, and be
Right.
on his show as witnesses. Thursday, we're still up in the air because we moved Doug from Thursday, and tonight we're working on somebody. But so that's so what do you all want to do who are watching this right now? Should we rerun this morning and then see you at 6? I say, Miss Shorty says, take some time off for yourself. See you at 6. And then you can put all your questions for us in the, I guess, do we leave the same stream on or do we portal a different stream? This is where you've got me on the technical, Michael Bryant.
Well, we can
okay?
do it either way. We can either, just let this run, and then when it'll end at 4-ish, we think.
Right.
But it would
Right.
be a separate stream for the 6 o'clock, and then we'd promote it as such. Hey, I found another
We're
note that I
portaling. We've
forgot.
been told what we're doing. We're portaling to tonight. Okay.
Okay.
So we
I
just let it
found
run.
another note that I had here.
Okay.
On the doctor, this was brought up at the very end, and I can't remember if it was Elizabeth Little or Alan Jackson because they look so much alike. I couldn't tell who it was, but they were talking about Dr. Welcher, and remember
Remind everybody who he is.
Dr. Welcher is the Commonwealth expert on Reconstruction. I think that's the
No,
easiest way to
isn't
put
he
it.
the one who's going to? Isn't he the neurosurgeon?
You may be right. It's the one that had the 140 slide presentation.
Yes, it's the neurosurgeon who's going to
talk about cause of death, right?
Well, what it is, he's not saying cause of death, he's saying mechanism of death. And the defense is saying, look, they're trying to get around the manner of death here that their experts won't make. Their forensic pathologists for the state won't make, and they're not calling, by the way, by calling the neurosurgeon, Dr. Welcher. Yes, and that's right. He came with what, 180 or 160?
It was 140 slides, and we don't. The ME may or may not appear. We don't know. We know that that Brennan has made it sound like they won't call him, but she's on the witness list. Anyway, this is my point. They were supposed to take that 140 slide PowerPoint presentation and whittle it down. Pull out the stuff that was more objectionable, right? And so Alessi said, we got nothing. Whatever they got last night, and it was still a mass of stuff. And so he wanted 2 more days from whenever they were originally supposed to respond to it. And nobody seemed to remember when that was. So I think the judge said, you got 2 days from now, but they're going to work on it. It just reminded me, you'll remember about this case. Here's all of the stuff. We're complying with discovery. Here it is. Just what we promised you. Right. Remember the Pinto case, the Ford Pinto case?
Yes, I remember the Ford Pinto case.
People remember that as a classic. That was the exploding Pinto back in the day in the 70s. The Pinto was a ugly little compact car that was very popular. And on one occasion, one was rear-ended. It happened more than one time, but this specific case, it was rear-ended on the freeway. The gas tank was too close to the rear. Boom, the car blows up. People died inside. And so a big class action suit began, which really attacked Ford Motor Company and all of these Pintos for having manufactured them with this gas tank too close to the rear bumper, causing potential fire. So Ford Motor Company, as the defendant, complies with production requests and fills up a room with boxes. I mean, a room, probably bigger than my office here, which is massive, of course. No, I mean, it's just like box after box. And what they did was buried inside one of those boxes in a folder was the smoking gun, the memo, where Ford Motor Company basically calculated the cost of paying for these claims versus retooling and reproducing the Pinto in a way that would be much safer. Game over.
And by the way, that's what corporations do when you sue them. They give you want everything, here it is. Okay, here
Good luck
it is,
finding
right?
anything in there.
And then when you come and they say, well, but you can't have them, you have to come to our facility and look at them, even if it's electronically. You have to go there. It's like when you go to the state police and you have to go to the lab, you have to go there with their lawyers there, and they'll show you everything they want to show you. And then they tab, right, or they mark everything that you're interested in if you ask for a copy of it or want a copy of it. So the secret is to say, okay, I want a copy of everything. All right, I want a copy. You two can play at that game.
Yeah. So that's what this reminded me of. That here's our 140 slide presentation. We've whittled it down a little bit, and it's still a pile of poop. So you still got to sift through it and argue about whatever you think is inappropriate here. I saw a note there from
Tara Ellis. She hasn't ruled on the death certificate issue. Yeah, I haven't seen that either.
Haven't seen that either. Yeah, undetermined. They want the Commonwealth wants the word undetermined redacted because it makes them look bad. So.
Yeah. All right. So we're gonna take a break. We're gonna rerun this morning's episode. I'm gonna take a screenshot of Alessi, send it to everybody, maybe post it on Justice Served TV, froze it in time, replay that a lot tonight. I mean, because I can't get over that. I mean, I just can't get over that.
It was a moment.
It was a moment. And then we'll come back at 6 and we'll take, we have so many questions from you that we haven't answered from Friday. They keep coming and coming, and we try our best.
So we'll try to cull through some of those if we can, but I expect there's going to be a ton of new ones as well. So.
No, we're not rerunning because anyone can replay this live. We're portaling. Okay, Dizzy just told us how we're doing this. Okay, again, excuse me, I'm not exactly the tech master here. All right, we are portaling into tonight's show, and you can go to the live, and you can see it. You can see, what is there. You can watch it, and we appreciate that you do watch the show from this morning to now, so you'll be ready for tonight's show because we're going to be at it.
With that premise. We'll
hit the like button
if we both get here or not tonight.
Hit the like button. Hit that like button if that premise. Hit that like button before you go. You have to hit that like button, the share, subscribe, and the notify, so that you'll get notified of tonight's show and you can put us into that algorithm, which you're all doing so great. We're really just growing like leaps and bounds because of all of you here. But please hit that like button before you go today.
All right, so we'll be back in a few, right? Until
Yeah.
until then, try to do the right thing. And here comes all those things Linda just told us